All right, good morning again. We are back and we are on the record. This is your first appearance before the Magistrate Court of Clayton County. Before we continue, everyone please raise your right hand. Do you swear or affirm that the information given to this court in your applications for court-appointed counsel? I hear a feedback. Let me see. Do y'all hear that audio feedback? Or is that just
We
me?
hear it. No, we hear it.
Okay. We'll try again. I think it's resolved. Do you swear or affirm that the information contained in your application for court-appointed counsel, as well as any information you will give this court this morning, is the truth, the whole truth, and nothing but the truth? So help you. So say I do.
I do.
Thank you. Please put your hands down. Again, this is your first appearance for the magistrate court. Ma'am, the shifting, can you stand still? You're very distracting. Thank you. This is the first appearance for the Magistrate Court of Clayton County. We are not here to try your case or to take a plea. You are here for the court to inform you of your charges that have been brought against you, to advise you of your rights, to set bail for those offenses that I am authorized to set bail for, to determine whether you require the assistance of an attorney, to schedule a preliminary hearing, and to appoint counsel for those of you who do not have counsel already retained. You have the right to remain silent and say nothing. Should you give up this right, anything you say during this and all other proceedings may be used against you if this case goes for trial. During this and all other proceedings, you have the following rights. You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to indictment by grand jury for most felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine witnesses who are called to testify against you. You have the right to compel the attendance of witnesses in your own behalf by subpoena. You have the right to testify and offer your own evidence should you choose to do so. However, should you choose not to, no presumption of guilt may be raised by your failure to provide any evidence on your own behalf. You have the right to have an attorney represent you. Ms. Cummings is represented by Ms. LaRoya Chester Jennings. She is a private attorney. She's here today to represent Ms. Cummings. For the rest of you, I have appointed an attorney to represent you. However, you always have the right at future court dates to hire your own counsel or to represent yourself. Some of you will be allowed to post unrestricted bonds for your release from jail pending the prosecution of this case. The bond may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of cash to the sheriff with any applicable fees, who will hold that cash bond until your case is resolved. Once your matter is concluded, that cash bond will be returned to the person who posted your cash bond. You may also consider using a bonding company who charges a percentage of the bond as a fee for their service. Up to 15% of your bond may be those fees. That will not be returned to the person who posted it. You may also have someone post a property bond. A property bond is where they will put your property up in exchange for your bond, but that property must have a net equity 3 times the amount of the total bond in order to qualify. So for example, if your bond is $2,000, your property must have equity of at least $6,000 to qualify for a property bond. Please do not ask me how much your bond is going to be if you use a sheriff or a bonding company or things like that. Most lawyers do not know how to do quick math, and that's not my job. So I'm going to just give you the bond that I set, and then you will determine if you can make that bond either using cash, commercial, or property. All of you will have special conditions on your bond. At minimum, you will not be prohibited to violate any laws while out on bond. There may be additional conditions for some of you that prohibit you from going around certain people or returning to certain places. All of these special conditions are considered important and serious by the court. And if you violate those special conditions, your bond will not be revoked, your bond will be revoked and you will not be entitled to a new bond while awaiting trial. Additionally, you may have new charges that are more serious in nature, such as influencing or intimidating a witness, aggravated stalking, or charges of that nature that carry with them. Ma'am, can y'all have her sit down? She's very distracting. Have her sit down, please. She can sit down. She's still gonna have her court today, but I just can't look at this shifting and things like that. Have a seat, ma'am. As I was saying, there may be additional more serious charges that may be brought against you, where there are fines of up to $20,000 or prison time of up to 10 years in prison. So please, please, please take these special conditions that I give you very seriously. If you have family members or friends who are watching who would seem to assist you with posting your bond, they should wait at least an hour to 2 hours after the conclusion of this calendar before attempting to post your bond, because it does take some time for the paperwork to get processed. It is worth noting that if your friend or family member is the alleged victim, he or she will not be permitted to post your bond, as the court has put in no contact clauses with any and all alleged victims. Some of you are charged with offenses for which the court is not authorized to set bail or bond. In this event, a bond hearing will be scheduled before a superior court judge, and you'll be informed of that date. If you are currently on active probation, this court is not authorized to set a bond in your case. Your probation officer will have an opportunity to review the charges to determine whether or not he or she wishes to move forward with securing a probation warrant or things of that nature, and it often occurs at a preliminary hearing. Please listen up as I discuss preliminary hearings. The preliminary hearing is an opportunity for the court to determine if there is enough evidence or probable cause to justify keeping you detained until your case goes to trial. If you are facing misdemeanors only, you have the option of waiving your preliminary hearing, which will move your matter through the magistrate court quicker so that you will have your first day of court more soon in the state court of Clayton County. If you waive your preliminary hearing, you are not waiving your right to counsel, you're not waiving your right to trial, you are not waiving your right to bond. You are merely saying, I believe that there is enough probable cause to get this case out of magistrate court to state court. You will have the option to waive your preliminary hearing today, and if you do that, you will sign your waiver. If you pay your bond or you bond out, that's an automatic waiver of your preliminary hearing. Just keep that in mind. If you are facing felony charges, I have already set a preliminary hearing for you. However, you and your counsel may determine that you wish to waive it at a later date. We're going to move quickly, efficiently, and respectfully through this calendar. We will take the female inmates first, starting with Ms. Cummings. After that, we will take the gentleman. Let's move forward. Tamara Cummings or Samara Cummings. Ms. Chester Jennings, that's your client.
Yes, Your Honor. Good morning. For the purpose of moving this case along, we would be waiving our preliminary hearing and just requesting a bond on this matter. Miss, if you like, I'm happy to give you some background information about this case.
You can, counsel.
So, Your Honor, on or about October 16th, 2022, this matter, the same incident, there have been no additional incidences since then came before this magistrate court, before the Honorable Judge Daniel Nagel. The charges at that time were affray. Miss Cummings was arrested at Clayton State University, essentially defending her daughter, and she was the person who called the police, but in this incident, the Clayton State University Police Department made the determination to arrest her. It was dismissed. She has since then turned herself in because the police department essentially contacted her after this case was dismissed and told her that there were new warrants out, and that is when she retained counsel. Miss Cummings has lived in Georgia for over 20 years. She has been married for 26 years. All of her 3 children live here, Your Honor. She has no flight risk. She has absolutely no criminal history prior to this incident occurring. There were several mitigating circumstances that Miss Cummings attempted to do, include contacting university housing about the issue that her daughter was having. Your Honor, we believe this issue should be resolving itself pretty quickly because Ms. Cummings' daughter will be attending a separate university soon in the very near future after she completes Clayton State, after she completes, I believe, this semester. Your Honor, she has started counseling as a result of this incident that occurred with the roommates on Clayton State University campus. And so, Your Honor, just considering all the facts, despite the warrant and the charges themselves, we are asking for a signature bond, or at the very least, a very low bond, Your Honor. As I understand it, there are two warrants. One, I'll be honest with the court, I don't understand. It's called a provoked battery of some sort. If the court could give me just at least the case law on that one, but I know that she's been charged with simple battery.
I won't give you the case law, but I'm happy to read the warrant to you. So you
I'm
can.
sorry, not the case law, Your Honor. I'm sorry, the code section that
Okay,
they are.
this is the battery section. It is 16.523.1A.
Okay. Thank you, Your Honor.
You're welcome. I'm gonna deny the request for an OR, a signature bond. It is the policy of Chief Keisha Wright Hill that we do not do signature bonds, although I do understand the counsel's argument. And I do understand that Ms. Cummings has no criminal history. It is not the policy of this court to do signature bonds in any case. So I'm not picking on her. It's just something that we do not do. In light of what you shared with the court, though, I will reduce the bond $1,500 for each charge, for a total of $3,000. And you said she will be waiving her bond, excuse me, her preliminary hearing.
Yes, Your Honor, for the purpose of getting bond, she will be waiving her preliminary hearing. Your Honor, if there's an option that she does not waive her preliminary hearing but still gets bond, we'd accept that option. But I don't know.
The jail is they're gonna waive it as soon as she bonds out, so it's an automatic waiver. So she does want to waive it, because I can set it for you now, but as soon as she bonds out, which I know she's gonna do later today, it's gonna be waived anyway. So it'll make.
Understood, Your Honor.
It doesn't matter to me either way. You want to go ahead and waive it?
Yeah, yes, Your Honor, we'll waive it.
Okay. All right. So we're gonna, Ms. Cummings, please sign the waiver in front of you. And Ms. Chester Jennings, like I said, is $1,500 for each count, making her bond $3,000 total. And if there's nothing else you have before the court, you are free to go now.
Yes, Your Honor, thank you. It was a pleasure.
Yes, Your Honor. Yes, Your Honor. It's talking to me. Have a good day, counsel. It's Sunday.
Yes,
I'm tired.
Thank you. You too.
Thank you.
Bye.
Good morning, ma'am. Give me one moment. Are you Ms. Herron?
It's Daniels.
Ma'am, you were charged with public indecency. Do you understand your charge?
Yes, I do. But my last name is Daniels. Oh, okay.
What'd you say, ma'am? You said you understand your charge?
No, all I know is that my last name is Daniels, not Harrell.
I'm looking for Sandra Herron.
I'm the same person. I just been married. I'm divorced. My name is Daniels.
Okay, yes, ma'am. Give me 1 second.
I'm the same person.
Okay. We'll try this again. Your name is Miss Karen Daniels, or Daniel, you're divorced now, you said?
It's not Aaron.
Hey,
It's
don't yell. Chill, chill.
No, she's not trying to yell. She's just trying to make sure I understand she is divorced, right? Okay. We gonna breathe. Ma'am, you understand your charge of public indecency. Your bond is $2,000. You are charged with a misdemeanor. Do you wish to waive your preliminary hearing?
I have to have another hearing.
Yes, ma'am. It's gonna be on December 6th at 8 a.m. in room 201. Have a good day, ma'am.
Sure, I have to have another hearing. I mean, another hearing, cause she here.
All right. Ms. King should be next.
Oh, okay. Put your name in there.
Yes. Oh, Naisha King.
Naisha King,
Yes.
give me one moment. All right, Ms. King, you are charged with DUI, improper lane change, and a red light violation. Do you understand your charges?
Yes, ma'am.
You say yes, ma'am.
I understand.
On the DUI, your bond is $5,000. On the improper lane change, your bond is $500. On the red light violation, your bond is $500, for a total of $6,000. Do you are you able to make bond?
Yes, ma'am.
A condition of your bond is that you shall not violate any laws or out on bond. You understand that special condition?
No, can you repeat yourself?
A condition of your bond is that you shall not violate any laws while out on bond. You understand that special condition?
Yes, ma'am.
These are misdemeanor charges, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Can you explain that?
I've already explained it, ma'am. Your next court date will be December 6th at 8:30 a.m. in room 201. Have a good day.
Thank you.
You're welcome. Next.
I'm ready. McLean.
Sure.
McLean, Coretta McLean.
Give me 1 second, ma'am.
Okay, thank you.
You're welcome. Ms. Thomas, am I going too fast? I know you normally track very quickly with me, but I just want to make sure I'm not going too fast.
No, Your Honor, you rocking and rolling.
Love to hear it, love to hear it. All right, Ms. McLean, you are charged with criminal trespass. Do you understand your charges?
Oh, yes, ma'am.
Your bond is $3,500, and you shall not violate any laws while out on bond. Are you able to make bond?
I'm gonna check. I'm gonna make some phone calls and see.
Okay. This is a misdemeanor. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
And if I do that, will I go to court soon?
Yes, if you do not make bond, they're gonna move your matter to state court, and where you plead not guilty, and have your trial set, or you can plead guilty and get everything resolved sooner.
So when if I go ahead and tell you I want to waive that, that means that I'm fast tracking. That's what that fast track stuff information
Fast
is.
track is a little different, but it is gonna move your case from magistrate court to state court. Would you wish to do that?
It'll move it sooner.
Yes.
Okay, that's what I want to do.
Okay, please sign your waiver, leave it with the deputy. Your next court date will come in the mail. If you, for some reason, are not bonded out, they'll bring you over for your arraignment, okay?
Do you know when it'll be, the arraignment will be?
No, ma'am, I don't.
Also, I don't have another court date listed in the
You
computer.
just waived your preliminary hearing, ma'am. They're gonna bring you over when you're ready to go forward. If not, your preliminary hearing is gonna be on December 6th, but that's still gonna be in magistrate court, which is not moving the matter quickly like you want it to do.
Okay, I want to move it quick as
Okay, so
possible.
sign the waiver with the deputy. They'll get that through the process and through the system, and you have a good day, okay, ma'am?
Actually, I want to ask you one question though. When you process.
You can ask her last, it's her last question. What's your question, ma'am?
criminal trespass holds how many days regularly when you weigh it out?
That's gonna be a question for your lawyer, who I've appointed to represent you. Have a good day, ma'am.
Okay, thank you.
You're welcome. Namul Ross, and I apologize if I pronounced your name wrong.
Hello,
What's your name, ma'am?
Lamar Ross.
Ms. Ross, give me 1 second. Ma'am, you're charged with simple battery. Do you understand your charge?
Ma'am.
You said you do? Your bond is $3,500 and you shall stay away from Ryan Mickey, and you shall not violate any laws without on bond. Do you understand?
Ma'am.
Are you able to make bond?
I'll make some phone calls, cause I'm.
Okay, this is a misdemeanor offense. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yeah,
Don't say yeah to me. We're not homies. It will be yes or no.
Yeah.
Do you wish to waive your preliminary hearing?
yes,
Okay, please sign your waiver. Leave it with the deputy. Your next court date will come in the mail. Have a good day. Are you Ms. Zellers?
Yes, ma'am.
Give me 1 moment. Ms. Zellers, you were charged with a felony count of violation of the Georgia Controlled Substances Act, use or possession of drug-related objects, and battery family violence. Do you understand your charges?
Yes.
On the felony drug charge, your bond is $15,000. On the use or possession of drug-related objects, your bond is $1,500. On your battery family violence, your bond is $3,500 for a total of $20,000. A special condition of your bond is that you shall not have any contact with Tommy Zellers, and you shall not return to 1950 Eshelman Court in Atlanta, Georgia. You shall also not violate any laws while out on bond. Since that is a shared residence, I will allow you to go with the sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property for any reason until this case is resolved or until that condition is modified by another judge. Do you understand?
Yes.
Are you able to make bond?
Yes.
Your next court date will be December 5th at 8:30 a.m. in room 201. Have a good day.
Thank you.
Y'all come on, go, guys.
That should be all of the female inmates, correct?
Yes, ma'am.
Did y'all say yes? I couldn't hear you. I'm sorry.
Yeah, that's all the females.
Okay, y'all ready? Mr. Allen?
Yes, ma'am.
Are you Mark Allen? Please close your shirt for me if you can.
Oh, my.
Thank you. Sir, you are charged with driving on suspended license, no tail lights, no insurance, expired tag, and concealing the identity of a motor vehicle. Do you understand your charges?
Yes, ma'am.
On the license tag charge, your bond is $1,500. On the tail lights, your bond is $500. On the tag charge, your bond is $500. On the no insurance, your bond is $1,000. On the concealing the identity of a motor vehicle, your bond is $500 for a total of $4,000. Are you able to make bond?
No, ma'am.
I can't hear you.
No, ma'am.
You shall not violate any laws while out on bond. These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Ma'am.
Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. Have a good day. Hey, Ms. Attico or Attico.
You'll be out in that area.
So you were charged with false imprisonment, which is a felony. Do you understand your charge?
Not all the way, no.
I can't hear you.
Not all the way, no, I'm sorry.
It is alleged that you intentionally and without legal justification committed the offense of false imprisonment, that you did not let your girlfriend, the alleged victim, Alyssa Fayyad, leave a bedroom in a residence that you both share at your Garden Meadows, Riverdale address by blocking her with your body and restricting her movement, that you would sit intentionally in front of the victim and continue to belittle and demean her, restricting her from leaving so you could fuss at her about infidelity. That's the allegation. Your next court date, your bond is $15,000. You shall stay away from Alyssa Fayyad. You shall not return to 6194 Golden Meadows Court in Riverdale, Georgia. You shall not violate any laws out of bond. It was indicated that that is a shared residence. As such, you may go with the sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without a sheriff's escort for any reason until this case is resolved or until that condition is modified by another judge. Do you understand?
Yes. Yes.
Are you able to make
Yes, ma'am.
bond?
Yes, ma'am.
Your next court date will be December 5th at 8 a.m. in room 201. Have a good day.
Will I be able?
Your name? Banks.
Give me one moment.
All right.
Mr. Banks, you are charged with soliciting a transfer of a firearm and battery family violence. Do you understand your charges? You now have a bond on the felony firearms charge. On the battery family violence, your bond is $10,000. Condition of your bond is you should stay away from the Judah Ansley, and you shall not return to the address that you all share at 8972. Do y'all live at the Homewood Drive place or the Terra Boulevard?
Yeah, I stay in Homewood. That's my house. I'm the leaseholder. She don't stay there. We don't share addresses.
You should, well, you don't have a bond right now anyway. Should you get a bond, you should stay away from Miss Ansley. You understand that, right?
Yes, ma'am.
Your next court date is going to be December 5th at 8:30 a.m. in room 201. Have a good day.
You too. You have a blessing.
Thank you.
Your name?
Christopher Bonilla.
Yes, ma'am.
Give me 1 second.
Don't say it.
Like, come to the right so they can see you. They can start to go right here. Yeah, when she turn her head back over, she can't see you right there.
Sir, you were charged with improper lane change and improper stopping in DUI, let's say. Do you understand your charges?
Yes, ma'am.
On the improper lane change, your bond is $500. On the improper stopping, your bond is $500. On the DUI, let's say, your bond is $17,000 for a total of $18,000. And you must not violate any laws out on bond. Do you understand the special conditions?
I do.
Are you able to make bond?
Yes.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
I do.
Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. Have a good day.
Next to the thing.
Ryan Campbell.
Yes, ma'am.
Mr. Campbell, you are charged with violation of the family violence order. Do you understand that charge?
Kind of, sorta.
It is alleged that you violated the family violence order when you intentionally stayed at the home of the victim, Prudence Baptiste, and you violate the court's order that you were hiding in the attic to avoid contact with the victim, and that this occurred in Clayton County, Georgia. You are receiving a bond on this charge only because this is a misdemeanor offense. While you are innocent until proven guilty, you have arrests from September of this year and October of this year dealing with family violence. If you come before this court again for any reason, your bond will be revoked and you will not receive another bond. Do you understand?
Ma'am.
This is on the record that is clear. You should have no contact with Ms. Baptiste at all.
Yes, ma'am.
Like I said, the bond is $50,000, Ms. Thomas, not 5,000, 50. And that is because as the court, we are supposed to make sure that you will not be a flight risk or that you will not reoffend. I am very concerned with the fact that you have charges from September and October of this year, and it's November.
Yes, ma'am.
As stated, you are innocent until proven guilty. Because those are not convictions, the court will give you a bond on this misdemeanor charge. But if you violate this order in any way,
Yes, ma'am.
you will be held without bond.
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Your next court date, Ms. Thomas, I'm gonna go ahead and set it for December 6th at 8:30
My name is-
a.m. in room 201.
Yes, Your Honor.
Have a good day, Mr. Campbell. Marquise Edwards should be next. So you were charged with forgery in the 3rd degree, trafficking in methamphetamines, possession of a controlled substance with intent to distribute, and giving a false name or date of birth. Do you understand your charge?
Yes, ma'am.
You said yes?
Yes, ma'am. I understand.
Give me 1 second.
So he going back to the, we may be going back to the center. We got, so you got this.
You do not have a bond on any of the charges except for the misdemeanor, giving a false name on that misdemeanor charge. Your bond is $5,000. However, you do not have a bond on any of the felony charges. Your preliminary hearing is scheduled for December 5th at 8 a.m. And your bond hearing is scheduled for, give me 1 second. December 9th at 8 a.m.
Excuse me, Your Honor.
I'm sorry, Ms. Thomas, did I get that wrong?
Yes, for the bond hearing, it would have to be scheduled for Superior Court.
Okay, so the Superior Court will schedule your bond hearing. What I'm gonna do is just put it down though, Ms. Thomas, just so we can have that. We tried to put something down there, but he'll know that he'll have to get scheduled based on his charge with Superior Court.
Yes, Your Honor.
Thank you. Have a good day, Mr. Edwards.
All right,
All right, good. Hey, y'all see my good? Yeah. Next up. So your name for me, sir? Tell your name.
Good afternoon, Your Honor. My name is Dexter Finney.
Good afternoon. Give me 1 moment.
Okay.
Take forward, where you at? Rodney. He's next door to
Are you charged with a felony count of the violation of the Georgia Controlled Substances Act? Do you understand your charge?
Yes, ma'am, I do.
Your bond is $7,000 and you should not violate any laws out on bond. Are you able to make bond?
Yes, ma'am, I am.
Your next court date will be December 5th at 8 a.m. in room 201. Have a good day.
Excuse me, Judge, I couldn't hear the court date. You said December the what?
5th, December 5th.
Okay.
Have a good day.
All right, thank you, Judge. You have a great day.
You're welcome. Thank you.
Good afternoon, Your Honor. My name is Talbot Jenkins.
Give me 1 second. Mr. Jenkins, you were charged with DUI, less safe and improper lane change. Do you understand your charges?
Yes, ma'am.
On the DUI, your bond is $7,000. On the improper lane change, your bond is $500, for a total bond of $7,500. Condition of your bond is you shall not violate any laws of out on bond. Do you understand? Do you understand?
Yes, ma'am. Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
These are misdemeanor offenses. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No, ma'am.
Your next court date will be December 6th at 8:30 a.m. in room 201. Have a good day.
December 6th
Yes,
in courtroom 201.
yes. If you bond out, it's going to be waived, which you said you're gonna bond out, but if you
Yes,
don't bond
ma'am.
out, it'll be December 6th at 8:30 a.m. in room 201. Have a good day.
Good afternoon, Judge. My name is Lawrence Kelly.
Moment. You're Mr. Kelly?
Yes, ma'am.
So you're charged with theft by receiving stolen property and a stop sign violation. Do you understand your charges?
Yes, ma'am.
On the theft by receiving stolen property, your bond is $10,000. On the stop sign violation, your bond is $500 for a total of $10,500, and you shall not violate any laws of out on bond. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Your next court date will be December 5th at 8 a.m. in room 201. Have a good day.
All right. You said this December 5th or December 8th?
December 5th.
Okay. Thank you.
You're welcome. Have a good day.
Two.
Thank you.
Organization statute.
Ryan Mackey.
I need Sindrell Lee. Did he bond out?
Yes, ma'am, he bonded out already.
Okay, thank you.
So you got the Dennis on.
Ryan Mickey.
Yes, ma'am.
No.
You're Ryan Mickey.
Yes, ma'am.
You were charged with obstruction of an officer and terroristic threats. Do you understand your charges?
Yes, ma'am.
For the obstruction of an officer, your bond is $5,000. For the terroristic threats, your bond is $5,000 for a total of $10,000. And you should not violate any laws of out on bond. Do you understand?
Okay. Yes, ma'am.
Are you able to make bond? Are you able to make bond?
Yes, ma'am.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No, I do. I don't. I want to have it.
Your next court date will be December 6th at 8 a.m. in room 201. Have a good day.
Thank you, about you say.
Are you Calvin Pete?
Yes, ma'am.
Give me one moment.
Ma'am.
Give me one moment. Mr. Pete, you are charged with theft by shoplifting. Do you understand your charge?
Yes, ma'am.
Your bond is $2,000. A condition of your bond is you shall not return in Lake City IFM, and you must not violate any laws or out on bond. Are you able to make bond?
Yes, ma'am.
This is a misdemeanor charge of shoplifting, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No, ma'am. Waive it. What you mean waive it?
We already talked about that. If you don't understand, that's fine. I'll go ahead and set it down for December 6th at 8:30 a.m. If you decide that you can bond out or you speak with your lawyer, you all can waive it at a later date. But for now, since you don't understand, I'm going to set your court date for December 6th at 8:30 a.m. in room 201. Have a good day, sir.
All right. Yes.
Good morning, Your Honor. How you doing today?
Good morning. I'm fine. Thank you. Give me 1 second.
Yes, ma'am.
Are you Mr. Pittman?
Yes, ma'am, I am.
Mr. Pittman, you are charged with 3 counts of forgery in the 3rd degree. Do you understand your charges?
Yes, ma'am.
For each charge, your bond is $10,000 or a total of $30,000, and you shall not violate any laws of out on bond. Do you understand?
Yes, ma'am, I do.
Are you able to make bond?
Yes, ma'am, I am.
Your next court date will be December 5th at 8:30 a.m. in room 201. Have a good day.
Okay, thank you, ma'am. You have a blessed day as well. Thank you.
Thank you.
Good morning.
Good morning. Are you Mr. Ponder?
Yes, ma'am.
Give me one moment. Sir, you are charged with possession of marijuana less than an ounce. Do you understand your charge?
Yes.
Your bond is $1,500. The condition of your bond is that you shall not violate any laws of out on bond. Do you understand? Are you able to make bond?
Ma'am.
How old are you?
20.
This is a misdemeanor offense. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Ma'am.
Please sign your waiver, leave it with the deputy. Your next court day will come in the mail. Have a good day.
Good morning, Ms. Thomas.
Good morning. Are you Raina Guruvere Singh?
Yes.
Give me one moment.
Sure.
You are charged with impeding the flow of traffic, driving under the influence, use of possession of drug-related objects, and open container. Do you understand your charges?
Yes.
Your bond on the impeding traffic is $500. On the DUI is $10,000. For use and possession of drug-related objects is $1,500. And for open container is $500 for a total of $12,500. And you shall not violate any laws without on bond. Do you understand?
Yes.
Are you able to make bond?
Yes.
These are misdemeanor offenses. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yes.
All right. Sign your waiver, leave it with the deputy, and your next court date will come in the mail. Have a good day.
Thank you.
Thank you.
Ma'am, do you know how much the bond is gonna be?
$12,500.
Okay.
Hello? Give me one sec.
What is that?
Miss Stanley, excuse me, Miss Thomas, will you remind me on your calendar, did Namu Ross waive?
Yes, Your Honor.
Thank you.
And
And you, Mr. Sampson?
No, Mr. Scott.
I mean, Ricky Sampson?
Hey, hey.
Are you Mr. Sampson?
Yes, ma'am.
You're charged with aggravated assault and legal possession of a weapon. Do you understand?
Yes, ma'am.
You do not have a bond on these charges. Should you get a bond, a condition of your bond will be to stay away from Rosetta Palmore and not return to the address on Brookwood Boulevard, but as stated, you do not have a bond at this time. Your next court date will be December 5th at 8 a.m. in room 201. Have a good day.
Okay.
Marquez Scott,
Yes, ma'am, it's me.
give me one moment.
All the way down, left over right. Stand from the door, you see, stand on the back.
Sorry, I was getting a message from my sister, so excuse me. Mr. Scott, you are charged with criminal trespass. Do you understand your charge?
Yes, ma'am.
Your bond is $3,500. A condition of your bond is that you shall stay away from Sylvia Scott. You shall not return to Wexwood Drive. It was shown on the application for your arrest that this is a shared residence. As such, I will allow you to go back to the property with a sheriff's escort for the limited purpose of retrieving your personal property. You shall not go back to that property for any reason until this case is resolved or that condition is modified by another judge. Do you understand?
Yes, ma'am.
You shall also not violate any laws out on bond. Are you able to make bond?
Yes, ma'am.
This is a misdemeanor offense. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No, ma'am.
Your next court date will be December 6th at 8:30 a.m. in room 201. Have a good day. Are you Mr. Seaborn?
Yes, ma'am.
Give me one moment. You are charged with forgery in the 3rd degree, identity fraud, forgery in the 2nd degree, and possession of marijuana less than an ounce. Do you understand your charges?
Yes, ma'am.
On the forgery in the 3rd degree, your bond is $10,000. For the forgery in the 2nd degree, your bond is $10,000. For identity fraud, your bond is $10,000. And for possession of marijuana less than an ounce, your bond is $1,500. Condition of your bond is that you shall not violate any laws out on bond. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes. Sure.
Your next court date will be December 5th at 8:30 a.m. Have a good day. Simon Sakura,
Yes, ma'am.
you were charged with, please fix your clothes. You were charged with criminal trespass. Please close your You're closed for me. You're charged with criminal trespass. Do you understand your charge?
I really don't.
It is
'Cause I was at my-
alleged that you damaged the property of the victim, Jocelyn Sudar, without the consent of the property owner, and the damage thereto is $500 or less, and that you did force open the front door, which damaged the door frame and prevented the door from closing properly. Your bond is $3,500. A condition of your bond is that you shall stay away from Jocelyn Sudar. You shall not return to 11070 Southwood Drive in Hampton, Georgia. I will allow you, since that's a shared residence, to go with a sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without an escort until this case is resolved, or until that condition is modified by another judge. You must also not violate any laws out on bond. Do you understand?
Yes, ma'am.
Are you
how
able
much
to make
was-
bond?
How much was it?
$3,500.
No, I cannot.
You have a misdemeanor charge, which gives you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No.
Your next court date will be December 6th at 8:30 a.m. in room 201. Have a good day. Tyrone Taylor,
Yes, Your Honor.
give me 1 second. Sir, you were charged with murder and possession of a weapon during the commission of a crime. Do you understand your charges?
Yes, Your Honor.
You do not have a bond at this time. Your next court date will be December 5th at 8:30 a.m. in room 201. Have a good day.
No, you're accepted.
Kevin Balazs. Ms. Thomas, for the charge for Mr. Taylor, the first charge is denied pursuant to 17-6-1. The second is denied just based on judicial discretion.
Yes, Your Honor.
Thank you.
Thank you.
Mr. Balazs,
Yes, ma'am.
you are charged with criminal trespass or an unlawful purpose. Your bond
what?
is $50,000.
$50,000?
Yes, although this is a misdemeanor offense, you are innocent until proven guilty. However, based on my review of the warrant, you have received several criminal trespass warnings for this address.
But I have a question.
Do not
ma'am.
interrupt me. You received a warning in February of this year, March of this year, and April of this year. So you have a bond because this is a misdemeanor offense. However, the purpose of the bond, and the court has to set a bond in line with my judicial authority, which is to, number one, determine, will you be a flight risk or do you have a risk of reoffending? Again, you are innocent until proven guilty. Based on the allegation, you have consistently been arrested for being at this home after you've been warned not to be there. So the court has to put a bond in line with the allegation. A condition of this bond is that you shall not return to the 5610 Pine Ridge Place address in Forest Park, Georgia. And you shall not violate any laws of out on bond. Do you understand?
I don't, because I was at the 5604 Pine Ridge Place.
I already told you about that.
I apologize.
You do, I'm not asking, are you guilty or innocent? I'm asking, do you understand the special conditions that I've given you?
Can I just ask one question?
No, you can answer my question.
I understand, ma'am. I apologize.
Are you able to make bond?
I will try.
Do you wish to waive your preliminary hearing?
Yes.
Now, what question do you have for me?
What person am I supposed to stay away from?
I can't hear you. Say that again.
What person do I have to stay away from?
You have to stay away from that property. You cannot return to that property.
I didn't go to that property. Well, okay, I understand. I'll stop.
I just want to make sure you understand, because you can go back and forth all you want about where you've been and where you're not done. I didn't say you were guilty. Did I ever say you were guilty of it? No. I told you what you were accused of. You told me you understand. And my direction is not to go back there. You understand that?
I do.
Have a good day. Sign your waiver, leave it with the deputy. We have one person who is an alleged fugitive. We want to bring that person up now.
Yes, sir.
Olaf, how do you say your last name?
Thomas.
Thomas. Mr. Thomas. Good afternoon. Ms. Thomas, I promise you to be an hour. It's gonna be an hour, 10 minutes. My apologies, ma'am. Well, good afternoon. Well, good afternoon to you, sir. This is what is called an extradition hearing. A fugitive warrant has been issued for your arrest. You do not have charges pending against you here in Clayton County. However, you've been brought here today because you have charges pending for you against you in the state of Florida. And that state is requesting that you return to answer to the charges that were brought against you. It is alleged that you entered in the state of Georgia having a warrant out of Orange County, Florida for aggravated assault with a firearm, and they have indicated that they will extradite you. In accordance with the state laws of this state, the state of Georgia, you are brought here before me for an explanation of this proceeding. You have the right to contest the legality of this warrant and contest all proceedings, or you may waive your right to extradition proceedings and voluntarily be returned to the state requesting your detention. Before you inform me of whether or not you wish to waive extradition, let me explain to you the following rights. You have the right to be represented by an attorney. If you cannot afford an attorney, one will be appointed to represent you. If you desire to contest the legality of the extradition process, then you must file or have filed on your behalf a writ of habeas corpus. You will be allowed a reasonable amount of time to file such a writ. You may file a writ of habeas corpus to contest the extradition, but only with the following things. You can only contest the following things. First, whether the extradition documents are in order on their face. 2, whether you are charged with a crime in the state of Florida. 3, whether you are the person named in the request for extradition. And 4, whether you are in fact a fugitive. You cannot contest the issue of your guilt or innocence in this state. You are entitled to the advice of counsel in deciding whether to contest or waive extradition if you so desire. If you waive extradition, the state of Florida will have 30 days to come and get you. If they have not picked you up in 30 days, you will be released. If you contest extradition and the state is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days awaiting your extradition. Do you wish to waive extradition and to be returned to the state of Florida, or do you wish to have a formal extradition proceeding?
it's complicated for me, ma'am. I have to ask the question.
Sir, I can barely hear you. Please speak up.
So, let me understand. I need to go as quickly as possible to Florida to defend myself, to get to know what the charge is. So I was traveling without knowing that something was charged for me. I got called at the Atlanta check-in for Air Force.
Let me stop you.
Yeah, okay, it's not,
So,
I understand. As
You're about to
quickly as
tell me what
possible.
happened that brought you here, and while I understand, I don't want you to share anything that may implicate you further, okay? I'm not letting anybody
But-
give me any explanation, and I'm not gonna give you an exception. It is not appropriate for you to talk to the court about what happened without your lawyer here, because you may, in effect, share something that may hurt you or hurt your case. My only question is, do you wish to voluntarily return to Florida to answer to these charges?
Yes, I will voluntarily return to Florida to defend myself and request what the charges are and get a lawyer in place. And I have to do as quickly as possible. My return was for Sunday. My dog is in the kennel and I'm a consultant. I have to work for a living. I cannot be for a long time off.
I understand. So your dog is in the kennel, you gotta get back home. So go ahead and sign. You want to get this moving quickly. You said you want to waive. Sign those waivers. You have several original copies of the waivers in front of you. You'll sign each of them. They will return them for me for my signature. I will sign them today. I will return them to the jail and they will move you through the process. If you wish to hire an attorney to see if they can move the matter along quicker, that's absolutely fine. I wish you well, sir.
What was the decision I just made? Is that the quickest way to go to Florida?
You said you wish to waive and voluntarily return to the state of Florida.
Yes, yes.
That's what you just said to me. Is that what you want to do?
Yeah, is it the quickest way to, yeah, thank you, ma'am. Yes, it is.
You're welcome. Have a good day.
Thank you. Thank you very much.
Thank you. Is that all you have at the jail?
Yes, Your Honor. You got sign those papers, right? Sure.
I'm gonna stop the feed. Ms. Thomas, stay on for 1 second for me.
Okay, and you are Lorenzo Larry, is that right?
Yes, sir.
We saw you yesterday and we had a question about case number 22C, well, it started out as 22 CJ 864, and it does look like that was transferred to adult court. And so probable cause was found for one count of carrying a concealed firearm. And that's a $1,000 bond, one count of possession of a firearm on school property, $1,000 bond, one count of possession of a firearm by a minor, and that's a $250 bond. The case is now 22 CF 14229, and we'll appoint the Office of the Public Defender, if we didn't do so yesterday, to represent you as to this case, okay?
Yes, sir.
Yes, you're not to possess any weapons as a condition of release, no return to the school as a condition of release, if you
No
do
return
bond
to
out,
school?
okay?
Your Honor,
Sir,
may we add a no contact with any of the witnesses to that as well?
Yeah, no contact with any state witnesses while this is pending, okay?
I don't know.
All right, thank you.
Yes, sir.
Are you Desiree Figueroa?
Yes.
Ms. Figueroa, okay. Okay, Ms. Figueroa, the case is 22 MM 8276. We do find probable cause for one count of domestic violence battery.
The victim is also in custody, Your Honor.
Oh, that's that one, okay. We'll get to it. I don't think we need to move it up, but, it's Christopher,
I believe they have the same last name, Figueroa.
same name, okay. Christopher Figueroa?
He's here, Your Honor. He's here.
Can he come in at the same time?
Yes, if you so wish.
I just need to know what to do with them, whether they're going to be able to be with each other or not. We need to talk to maybe both of them, but we'll find Christopher here. Where are you, Christopher?
Your Honor, I don't know if it's relevant or not, maybe relevant, but she doesn't want to have no contact with him.
Okay, well
So
then,
you still want them to be in a separate room, same room but separate, or just?
no, he doesn't need to come in now. If she, you can't live together, though.
Okay.
I don't remember this. Do you live with him?
No.
Yes?
Yeah, in my house, in my apartment, but it's my apartment,
Okay.
and I live with him. I threw him out a month ago because he came to jail. He almost killed me.
Okay.
He came
Well,
to jail.
you don't necessarily need to get in the facts of anything here.
Sorry, my Honor.
Police officer couldn't determine exactly what went on. Both of you had injuries. We do find probable cause that both of you committed a domestic violence battery. We'll go from there. But I can set, let's see, Desiree does not qualify for PTR. So what we will do is we would set your bond in the amount of $1,500. We would order you have no contact with Christopher Figueroa as a condition of your release. That will require you to maintain separate residences. So if you own the place, you can stay there. I will let him know he's got to find other arrangements, okay? You're not to possess any firearms or weapons as a condition of release.
Sorry, sorry.
We will appoint the Office of the Public Defender to represent you, okay?
Okay. I don't want him, I'm sorry, my Honor, but I don't want him in my house for nothing.
Well, I'm going to let him know he's able to return. If he has any things there, he's got to be with the cops. He can return one time to get his things, but I'm going to let him know, other than that, he's not to go back there, okay?
Thank you, because Christopher been doing this already for his sixth time and I got everything.
Okay. Good luck. And if he's able to come in, we can bring him in since, can we get Christopher in here now? Thank you. And are you Christopher Figueroa?
Yes, I am.
All right, Mr. Figueroa. So we're going to do the same things with you that I just did with Desiree, I believe it was.
Yes, sir.
I do find probable cause for domestic violence battery. I did the same thing for her. I'm going to set your bond in the amount of $1,500. I'm ordering no contact. You not to have any contact with her. You do have to find somewhere else to live.
Yes, sir.
If you have some things there, you can return with law enforcement to return your personal belongings, but then you need to find somewhere else to live, okay?
So just call law enforcement to remove my stuff there?
Yeah, they'll give you some instructions on what you need to do before you get out of here today, after you post your bond. No contact, separate residences. We're going to order that you not consume or possess any alcohol while this is pending. And we will appoint the Office of the Public Defender. They will likely conflict off. And I think that's it. Oh, you're not to possess any firearms or weapons as a condition of your release, okay?
Understood.
All right, thank you, sir. Good luck. The next case is Joshua Brannon.
Your Honor, he's a refusal.
He refused?
Mm-hmm.
Okay, what would you like to do? He's got, his failure to appear,
I have no objections to waiving his appearance, Your Honor.
looks like it's a 21 CF 13646. It's a $1,000 bond. We can appoint the PD to represent him, but it was an FTA.
He also has a 2022 CF case.
Let's see, there it is, 2022 CF 1081. Okay, oh, that's right. Probable cause for grand theft of a motor vehicle, that would be a bond in the amount of $5,000. No victim contact as a condition of release there. Okay. Yes. Do not, no return, don't drive with a valid license, no weapons as to both. Okay. Thank you. No, that's, sorry, just on the second. And Renato Munoz?
Your Honor, he's a refusal.
You can waive his appearance, Your Honor. He was a reset from yesterday.
Okay. $500 bond. Okay. Thank you. And appoint the PD. Francis Wiltshire?
He is also a refusal.
You can also waive his appearance, Your Honor.
Okay, that was a PC for trespass. Appoint the PD, bond in the amount of $500, no return to the location. This gets us to Kevin Agueta.
I want to.
Are you Mr. Agueta?
Yes, sir.
Okay, I think you have two cases. Case 22MM8275, we do find probable cause for one count of domestic violence battery. It looks like you qualify for pretrial release. You don't have to post a bond. However, I would order you have no contact with the alleged victim. I think it's your sister, Jacqueline Lopez, okay? So you do need to maintain separate residences, okay, while this is pending as well. If you do live together and you need to get some belongings, you can return one time with law enforcement to obtain those. You're not to possess any weapons or firearms as a condition of your release. We'll appoint the Office of the Public Defender. I think you also have case number 22CF14304, where we do find probable cause for battery on a law enforcement officer, and we can set that bond the amount of $1,000. One count of resisting with violence, and that would be $150. We can appoint the PD there.
Your Honor, I do have a question. He qualifies for PTR on those two counts. You're still just issuing a bond, no PTR on the other two counts?
I guess, if he, does he qualify on both? I guess he would, is that right?
Yes, Your Honor.
All right, he can do PTR as to both, okay? Sorry about that. Thank you, sir. I'm sorry, what's the name?
Harper.
Crawford?
Harper. Because of the baby was crying. Harper.
It's from misdemeanor domestic violence.
Okay, thank you. Are you Deja
Yes.
Harper?
Yes.
Okay. Okay. Good morning, sir. Can you raise your right hand, please? Do you swear or affirm, or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
And can I have your name, sir?
Brian Matunda.
I'm sorry, last name is?
Matunda.
Natunda, okay. And what is your relationship with Miss Harper?
It's my girlfriend.
And where, do you live in Philadelphia, Pennsylvania?
Yes.
Okay, are you here on vacation?
Yes.
Orlando or Kissimmee?
Yes. Until tomorrow.
You're supposed to go home tomorrow?
Yes.
Okay. This is supposed to be the happiest place on earth, you know, Disney, right?
Yes.
Okay. I do find probable cause for domestic violence battery, okay? Y'all live together, I presume?
Yes.
This is your daughter?
Yes.
What's her name?
Mahaya.
Excellent, okay. And you're staying at a hotel, is that right?
Yes.
Okay. And you have a plane ticket tomorrow?
Yes.
All right. If she's able to get out today, do you want to have contact with her?
Yes.
Are you in fear of her?
No.
Did anything like this ever happened before?
No.
Okay. Any questions from the state?
No, Your Honor.
Mr. Matunda, if you're okay, if you're not in fear, I'm going to release her on her own recognizance, let y'all get back home. If the state decides to prosecute, she's got to come back here, okay?
Okay.
But just get home and see if you can work things out, all right?
appreciate
So we'll release her on her own recognizance with the instruction to have no hostile contact with Mr. Matunda, and we can appoint the Office of the Public Defender to represent her, okay? Good luck to both of you.
Thank you.
Thank you. Losing my voice. Are you Mr. Menendez? Yes, sir. Okay, good morning, afternoon, Mr. Menendez. All right, Mr. Menendez, I've reviewed the police report. I do find probable cause for one count of carrying a concealed weapon. We'd set your bond there an amount of $2,500. One count of violation of a domestic injunction, that would be a $5,000 bond. One count of obstructing justice, hindering communication with law enforcement. We'd set your bond there in the amount of $1,500. It's very important that you have no contact with the victim alleged here, Natalie Rangel, I believe. Because I suspect if the injunction is violated again, you might not get a bond. Mr. Menendez, you do not qualify for a court-appointed lawyer, all right? So if you need a lawyer on this, you're gonna have to hire one on your own. You'll get all of this in writing. I'm also gonna order that you do not possess any weapons or firearms as a condition of your release, okay? You need to stay away from her. Anything from the state?
Yes, we'd be asking that he not be within 500 feet of her work residence or the children's school.
I presume that's probably a condition of the injunction anyways, so
No, it's
he
not
needs to,
because it's temporary, and they have a hearing on the 13th.
okay.
Not finalized yet.
But whatever the conditions of the injunction are, I presume that would be one of them. But I can order that here. Don't go within 500 feet of her until this is dropped or the injunction runs its course, okay? Any questions? Yes. Okay, thank you, sir. Are you Miss Crawford? Okay, Miss Crawford is here. And someone is here to speak with you. Sir, can you raise your right hand, please? Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And can I have your name, please?
Philip Balthazar.
It's Mr. Balthazar. Okay, what is your relationship with Miss Crawford?
My girlfriend.
Girlfriend. Do you live together?
No.
You don't? Have you ever lived together?
We have before.
Okay, but, and do you have any kids together?
Yes.
Okay, and where do the kids live, or do you share them, or?
We share them.
Okay. So, Mr. Balthazar, I do find probable cause that you were the victim of a domestic violence battery, okay? If she's able to get out, the issue is going to be whether you want to have any contact with her or not.
I would like to have contact with her.
Okay, are you in fear of her?
No.
Has this type of thing happened before?
No.
All right, and if anything does happen, there's nothing anyone in this room can do to protect you, you'd have to call the police again. Do you understand that?
It won't happen again.
Okay. I think she qualifies for pretrial release.
Yes, Your Honor.
Right? Okay, so she won't have to post a bond. Ms. Crawford, we are just going to order that you have no hostile contact with Mr. Balthazar, but you're welcome to see him. Just no hostility. And we can appoint the Office of the Public Defender, okay? Good luck. Thank you, sir.
Thank you.
Are you Mr. Diaz is it Caballero?
Yes, Your Honor.
All right. All right, and then we have Miss, ma'am, can you raise your right hand? Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
And I put your hand down. I presume you're Natalie Diaz?
Yes,
And what is your relationship with Mr. Jose Luis?
he's my father.
Father, do y'all live together?
Yes,
Okay. I've reviewed the police report. I do find probable cause that you were the victim of a battery because y'all live together as domestic violence battery. If your dad is able to get out of jail, would you like to have contact with him?
yes,
Are you in fear of him?
no,
Has he hurt you or struck you before?
no.
Okay. Any questions from the state?
If anything like this were to happen again, would you be willing and able to call 911?
Yes,
And you said you're not in fear?
no.
No further questions?
Okay, so Mr. Diaz Caballero, you do qualify for pretrial release. So you don't have to post a bond. I am going to order that you have no hostile contact with your daughter, Natalie Diaz, as a condition of your release. We can appoint the Office of the Public Defender to represent you. If the state files a charge on this, you'll be notified and you have to go to court on that. You just got to wait and see what happens, okay? Okay. Thank you, ma'am. Good luck. Bye-bye.
Thank you.
Sorry. Take this one.
Yes, yes.
Are you Mr. Alberto Leon Jr.? Okay, good afternoon. All right, I've reviewed the police report. We do find probable cause for one count of domestic violence battery. Do you live in Miami or live here?
I live in Miami.
Miami, and I think you're married to Olga, is that right?
Yes.
Okay. And did anyone get in touch with Olga?
No, no, Your Honor.
All right. All right, so here's what we have to do. You qualify for pretrial release. You don't have to post a bond, but I'm going to order you have no contact with Olga while this is pending, okay? You're not to possess any weapons or firearms also as a condition of your release, and that's very important. We'll appoint the Office of the Public Defender to represent you. Look, you do have to maintain separate residences, okay?
We actually do. have
Okay.
separate Residents,
Okay,
so,
all right, then that's good, but while this is pending, no contact with her, it's important, okay?
yeah.
All right, good luck, sir.
One thing, I think it was at a hotel. I'm not sure if you have property still at the hotel?
Yeah.
Can you return one time with law enforcement to get the property at the hotel?
Right, if she's gone, you can go back, but if she's there, you think she might be there, you have to be accompanied by law enforcement to get your stuff, okay?
Or how about a security in the property or?
Law enforcement.
Police officer, yeah, OPD or Orange County Sheriff, okay?
I had put all my stuff in my truck. I was leaving. As I said, I told the security guard, I said, leave her in the apartment, I'll just leave. And then the cops came and whatever.
I understand.
You could help go with police to get your,
If you don't need to go back there, you don't have to, but if you do,
I'm gonna stay away.
okay, be good, good luck. Are you Mr. Prasad?
Yes, Your Honor.
All right, Mr. Prasad.
Thank you.
All right, we do find probable cause for one count of domestic violence, domestic violence. He does qualify for pretrial release, so you don't have to post a bond, you can do that. But I do order you have no contact with Jerry Divine Montero as a condition of your release. You do need to maintain separate residences. I don't think you live together, but if you do, you can't do that anymore. You can return one time with law enforcement to get your belongings. You're not to possess any weapons or firearms as a condition of your release. Mr. Prasad, you do not qualify for a court-appointed lawyer. So if you do want a lawyer on this, you're going to have to hire one yourself. You might want to wait and see what the state decides to do. If they file charges against you, you will need to hire a lawyer, okay?
I apologize. I didn't hear that last part.
If the state files charges against you, you'll need to hire a lawyer, but we'll wait and let them make a charging decision on this, okay?
Yes, yes, Your Honor.
All right, good luck.
May I make a statement?
Yes, but I suggest you say nothing about what happened here, because you could say something inadvertently to hurt your case, because it can be held against you if you say something incriminating. But do you have a question about the conditions I've given you, for example?
Yes, sir. This is my first time. The no bond, I'm not familiar with that.
Well, you don't have to post any money. You have to participate in what's called pretrial release. They will instruct you on that. They're going to require you to check in, maybe by phone, maybe in person. They will let you know. If you'd rather post a bond and not do that, I'll give you a bond.
No, sir.
Okay.
Appreciate
Okay.
it.
But it's important you have no contact with her while this is pending, okay?
Sir.
All right, good luck. All right, are you Mr. Adolphe?
Yes, sir.
All right. Mr. Adolphe, I think you have two cases, okay? 2022 CF 3945, both of them, and also 22 CF 3953. You got picked up on warrants for missing a court date, failure to appear.
Yes, Your Honor. Upon me getting released, from Seminole, I was unaware of the charges because they didn't file the charges and I wasn't notified of any court date. I was working Operation Blue Tarp for FEMA for the roofing, and when I came home, I guess I jaywalked and discovered I had these charges. And I was wondering if I can get a bond reduction
Well,
of the $5,000.
it's $2,000 on each case right now, and no, I'm not going to do a bond hearing now. We'll appoint the PD to represent you. If you cannot afford that, they will know what to do. But I think he's got a $2,000 bond on each case, doesn't he?
No, I believe it's 2,000 on one and 5,000 on another, I think.
But 5,000 on 3954.
Yes. One moment, please, Your Honor.
Okay. No, this is Adolphe? Jean?
This is in regards to the bond.
I'll give it to you, but it's
Judge, this just
what he came in on.
introduced. I know before that, then the motion has to be filed with that. We're done here, Your Honor.
Okay, so it's 5,000 on one and 2,000 on the other.
Yes.
Call a bonds person, see if you can make that. If you can't, the PD will know what to do, okay? Good luck, sir. Is it Chris Kafora?
Correct.
Okay.
I do have a PC argument for this case, Your Honor.
Okay.
So the charge is aggravated child abuse with a weapon. I don't see anywhere in the police report where it mentions great bodily harm to the child, and there was no injuries mentioned to the child, Your Honor.
Is great bodily harm an element of aggravated child abuse with a weapon?
I believe so, Your Honor. When I read the jury instructions, yes.
Okay. Okay, and anything from the state?
Yes, Your Honor. It's the state's position that the statute says that aggravated child abuse occurs when they commit an aggravated battery on a child, and based off the statute for aggravated battery, knowing or intentionally causing great bodily harm, permanent disability, permanent disfigurement, or using a deadly weapon. And it's our position that aggravated battery occurred because the use of the glass constitutes a deadly weapon. There's an touching with the glass would make it aggravated battery.
So the jury instruction in 2, I think it's the disjunctive. In doing so, the defendant intentionally or knowingly caused great bodily harm or used a deadly weapon.
Okay.
So the issue is whether, by the way, I want to commend you for going to the jury instructions. I tell my law students, this is where you start. Go straight to the jury instructions. But if the glass constitutes a deadly weapon, I think there's PC for that. So it's a good argument, but I think we do find probable cause for the offense of aggravated child abuse with a deadly weapon.
In setting bond, Your Honor, can you set a bond at an amount of a reduced amount?
Well, it comes in at no bond, so what, I mean, we can talk, I guess we can need to set an amount now. So
Yes, Your Honor.
what are you asking
Possibly-
for?
Give me 1 second. $2,500 if possible, Your Honor.
Anything from the state?
We would be asking for, I'd ask for a $20,000 bond, but I'll leave it at the court's discretion. I understand, I have it listed as an F1, so I think $2,500 is.
The reason
little low.
we're requesting $2,500, she has no relation to them. They were, I guess, tenants. They no longer live there. They were,
I apologize. They were trespassers. They actually were trespassed today.
I understand.
They squatters.
I wrote down, my initial thought was a $5,000 bond, so we'll stay with that, okay? There are mitigating circumstances, I understand. So even though it's an F1, we'd set it at 5,000. We would order no contact with the victim alleged. The first name is Zion, I believe, or his family. I don't
They
think
were
that's,
trespassed.
I don't think that's going to
They
be an
broke into
issue.
the house.
Okay, and we will appoint the office of the public defender. Okay, thank you. And can I have your name, sir?
Juan Canales.
Okay, and do we know what I've got Natisha Clark? Okay. So this is Mr. Chris Carbone? Okay, well, who's this? Okay, so it's Mr. Canales. Okay. Hi, Mr. Canales. We do find probable cause for one count of possession of methamphetamine. Bond would be set in the amount of $1,000. One count of possession of cocaine, a $150 bond. One count of possession of drug paraphernalia, that would be a $100 bond, and we can appoint the office of the public defender to represent you, okay? Thank you, sir. And are you Mr. Carbone?
Yes, sir.
Okay, Mr. Carbone. All right, so Mr. Carbone, you have two cases, I believe, 22 CF 14302. We do find probable cause for one count of fleeing police. With a disregard for safety causing injury, and also one count of leaving the scene of an accident involving an injury. I'm going to set bond the amount of $5,000 as to each count. As to case, and appoint the PD, 2022 CF 14303, we do find probable cause for the following: possession of a firearm by, well, let me do it this way: possession of ammunition by a convicted felon, $5,000 bond. One count of possession of a firearm by a convicted felon, that's a bond of $4,000. One count of possession of marijuana greater than 20 grams, $1,000 bond. One count of resisting without violence, a $500 bond. One count of removal of a serial number from a firearm, and that's a $2,500 bond as well. And we will appoint the Office of the Public Defender to represent you as to both cases. Okay? Thank you, sir.
That's a yes, sir.
That's your bond, yeah.
I'm good.
I do have a PC argument for the next person, Your Honor.
Okay. Are you Miss Clark?
Yes, sir. Good morning.
Good, I think it's afternoon already.
Yes, sir.
Okay, so she's got two cases. Which one? The robbery, I presume?
The robbery, yes, Your Honor.
Okay, go ahead.
My PC argument is the battery occurred after they're alleging that Ms. Clark tried to leave and the theft was already completed and she didn't take anything from the alleged victim. So I don't see how that's a robbery, Your Honor. Because it's theft, I believe, theft and force from a person.
Let's see. Okay, so in the middle, the police report indicates Natisha also was shown punching Tanaya when she was confronted trying to leave the store with the merchandise.
Yeah, that was after the merchandise was already taken.
But she's still in the store.
Yes, but from my understanding, the robbery would be theft and force from like taking the item from the person. I see the burglary aspect, but just not the robbery.
Response?
In the continuous series of events, she took the items and then hit the clerk. So it's the state's position that that does constitute a robbery because in the same transaction it occurred. Even though it wasn't taken from her person directly, it was taken from her possession.
Not that this is correct, but I've seen trials where this is, but I don't know if this would be burglary within a battery therein, which is PBL. I don't know if that does her any favors, does it? Ma'am, you don't need to talk to me, trust me, okay? But I do find probable cause. I appreciate the argument, I really do. It's clever, but I do think it's this continuous thing. If contact was made trying to get out with the merchandise, whether it happened or not is not the issue. It's just what's in the police report today. So I would find probable cause for the robbery, $2,500 bond, one count of burglary of an occupied structure, $5,000 bond, one count of petty theft, $250 bond, no contact with the alleged victim, no return to that 7-Eleven. She's also out on bond in case number 22 MM4169. That's a theft case as well, so bond would be forfeited there. And we'll appoint the Office of the Public Defender to represent her. There's another case, 22 MM8289, and that is petty theft, and that would be a $250 bond there, okay? Thank you, Ms. Clark.
Your out on bond case has been revoked. You'll be held on zero bond on this case. On the auto bond case, no. These cases, but you'll be held in custody with no bond because you're being held on this case.
Are you Mr. Crittenden? Okay, Mr. Crittenden. All right, Mr. Crittenden, case number 22 CF 14297. You have three cases. So we'll start with the 22 CF 14297. We do find probable cause for one count of possession of a concealed weapon, that's a $100 bond. One count of possession of cannabis greater than 20 grams with a weapon, that's a $15,000 bond. Case 22 MO1099. You got picked up on a warrant for failing to appear in court. And I think that is no bond right now.
I do see PTR that judge put for that one, pre-trial release.
Is that what that means? Okay. So the judge is allowing, the judge who issued the warrants, I hope I see that judge. PTR, 22 MO1358. Probable cause is found for open container, and that's a bond in the amount of $250. We can appoint the office of the public defender in all cases.
Yeah, 15,000. Your Honor, one moment, please. He has a question. I apologize.
Okay.
This is it, 15,000. No problem. We're done, Your Honor. I apologize.
Thank you. Are you Mr. Demps?
Yes, sir.
Okay, Mr. Demps. Mr. Demps, your new case is 22 CF 14261. We do find probable cause for fleeing or eluding law enforcement. And we would set your bond as to that case in the amount of $5,000. It looks like you're out on bond in two other cases, 22 CF 11595.
Yes, sir.
And that bond would be forfeited, okay? Same thing in 22 CF 12315. That's also a fleeing and eluding case, so those bonds would be forfeited. But we can appoint the PD to represent you in all cases, okay?
1 second, please, Your Honor. I apologize.
Revoke, I think the proper term is forfeit in estrete. Estreature.
Revoke's easier to spell.
I just say forfeit. Is that what you're like? My bond expert's Judge Craner. He says, no, we don't revoke bonds. So I just go, but.
Semantics.
Your Honor, if possible, we understand that you did revoke bond. No information has been filed yet in any of those two charges. Are you willing to set a higher bond after you've revoked it?
I understand, but no,
Okay.
not gonna happen. Thank you.
So I don't got no bond at all?
On the auto bond, but you have a new bond, but you'll be held on no bond on auto bond cases.
So that mean I ain't getting nothing?
No, you won't be able to get out.
Is there any way I can get a bond for those?
No.
No, lawyers will know what to do. They gotta go to the judge who's assigned to the case and request if that judge will give you a bond, okay?
There's no other way, sir, because it's like the way the charge was, I was already out, and they sent the warrant, it's basically like the same charge, the same, it's just when they came, it was a different car, and they come, and the warrant come pick me up out of the warrant. I just bonded out like a month ago for the same charge, not the same charge, but it's all in the same.
Hold on 1 second. Can I see his police report again? I'm curious about something.
I had a warrant, and I had another warrant when they picked me up for domestic violence, and all this was like basically fell under the same thing. arrest me again. I don't know what's the incident is, sir.
Well, the new fleeing and eluding was December 1st of 2022. If he's telling me that's the same incident as case 22 CF 12315, that I would take a look at, but I don't have that police report in front of me. But he's out on bond on an aggravated child abuse case, and I wouldn't,
Yeah, but, me and my, wife, we had,
you don't need to talk to me about that, okay? But that bond is gonna stay forfeited no matter what we do with the other one, so it's not gonna do you any good, okay? So we're gonna keep things as they are. Thank you.
so now one of the charges I got a bond on?
So I'll reach out to the attorney assigned to the case.
Are you Mr. Dent?
Yes, sir.
All right, Mr.
Good
Dent
afternoon,
is
sir.
here. All right, Mr. Dent, 22 CF 14319, we do find probable cause for petty theft with 2 prior convictions. We'd set your bond in the amount of $1,000 in order you have no return to the Calvin Klein on Vineland Street.
Yes, sir.
You're out on bond in case 22 CF 13879. Which is a felony Willis.
Defense will be asking that you take no action in regards to the case because it's a driving while license is suspended
Please,
charge,
sir.
Your Honor.
I have a funeral to go to, my grandmother's funeral, so please, if you can find it in your heart, please, please. I'm begging the court. This is my last respects to my grandmother, please, sir.
What do you debate? But anything from the state?
No objection to taking no action, as long as he doesn't drive to his grandmother's funeral.
Oh, I won't drive, ma'am. Thank you, sir.
No action. Good luck. We can appoint the PD.
Thank you, sir.
Are you Miss Dickerson? Okay. All right, Ms. Dickerson, we do find probable cause for uttering forged bills or notes. That bond will be set in the amount of $2,000. We will appoint the Office of the Public Defender to represent you, okay?
Your Honor, I am asking that you release her on RR in regards to the fact that she is 5 months pregnant and she doesn't have a criminal history from what I can see as well, Your Honor, and no failures to appear.
Anything from the state?
The state will not object to a reduction in the bond.
But ROR, what was it, 2,000? Okay. We can cut it in half, $1,000?
One moment, please, Your Honor, I apologize.
I don't know if 5 months pregnant is mitigating, okay? I don't mean to sound insensitive, but she's gonna be out well before the baby comes.
Is it possible if the bond could be reduced to $500? She does not have any criminal history in Orlando. She has no failure to appear. She stated that she was here on vacation and she does have to go back.
Is there a material difference between the two amounts? Is she gonna post a cash bond or go to a bondsman?
She said she does have cash on her.
That's what got her in trouble, right?
I understand. Well, I'm not, yeah, 1 second, Your Honor. She has no.
And one of these $50 bills, I mean, I read 100 police reports say, but these are $50 bills that someone claims are fraudulent, right? Counterfeit?
Yes, Your Honor.
So,
She said the cash was checked prior to her, I guess, being placed in.
we cut it in half, 1,000 is as good as it's gonna get, okay? We can appoint the PD. Good luck, ma'am. Okay.
If you could reach out to a bond. 1 moment, please, Your Honor, I apologize. Okay.
Are you Mr. Hurst?
Yes, sir.
Okay, Mr. Hurst. Mr. Hurst, case 22 CF 14310, we do find probable cause for 1 count of battery on a law enforcement officer. That bond will be set in the amount of $2,500. 1 count of Resisting without violence, that would be a $100 bond. And we will appoint the Office of the Public Defender to represent you, okay?
Yes, sir.
Thank you. Good luck, sir. Are you Miss Lowry?
Yes, sir.
All right, Ms. Lowry, case 22 CF 14313, we do find probable cause for one count of possession of methamphetamine, that would be a $1,000 bond, one count of possession of less than 20 grams of marijuana. We can ROR on count 2. She's out on bond in 22 CF 7163, controlled substance case. Do we know if the state is gonna actually file on that or not?
It was filed on, Your Honor.
It was?
Yes.
That doesn't help her.
No. I can't lie. You can check.
No, I'm not saying,
Okay.
but I'm just saying. Ms. Lowry, are you currently employed? Do you work?
No, I've been looking for work. I've been trying to change my life ever since I first got arrested. I did application for gyros.
Do you have a stable household, or are you moving around?
I have a stable household.
And who lives there with you?
My mother lives with me, and my mother lives with her grandpa. So
Do you have any children?
I have 3 children, 2 girls.
How old are they?
A 10-year-old, a 4-year-old, and a 2.
Do they live with you or somewhere else?
No, they live somewhere else for temporary custody until I get situated to my own apartment.
Do you have anything going with the Department of Children and Families, DCF, like a parenting case plan or something like that?
No, I have a temporary custody case for one of my kids, but no like DCF other than food stamps, like with them.
DCF plan with the kids. If you don't have temporary custody for one, do you have any for the other 2?
No.
We won't,
Just for one of my
take any action on the bond, okay? Please be careful.
Thank you so much.
Good luck, bye-bye.
I apologize. What was the count 1? What's the bond for count 1? Or is that RR as well?
It was 1,000.
1,000, okay.
1,000 count 1 and ROR count 2.
Yeah. No action on out-of-bond cases.
Thank you so much.
Good luck, bye-bye. Are you Mr. Markland?
No, sir, he's a refusal.
Okay,
Defense have no objection to waiving his appearance, Your Honor.
okay, so there's probable cause for possession of fentanyl. The bond would be $1,000. We can appoint the PD to represent him, okay? Are you Mr. McCrimmon?
Yes, sir.
Mr. McCrimmon is here. 22 CF 14323. Mr. McCrimmon, we do find probable cause for one count of possession of fentanyl, and that would be a $1,000 bond. One count of possession of cocaine, $150 bond. One count of possession of Xanax, $150. One count of possession of drug paraphernalia, and we can ROR you as to that count. Because he heard what I just did, we won't take, he's out on possession of cocaine, we'll take no action on that bond, and we can appoint the public defender to represent him, okay?
Thank you, sir.
Yeah, so
You should be, if you're.
It's 22. Possession of cocaine? Is this not right? Hold on one second. Oh, on 2, okay. And it Willis. Okay, so on both of those cases, we're not going to take any, 22 CT 432. Mr. McCrimmon will be careful, okay?
All right, thank you, sir.
Good luck.
Have a great day.
Be careful. All right. Are you Mr. Hector Rodriguez Serrano?
Yes, sir.
Okay. Okay, this is case 22 CF 14307. We do find probable cause for one count of aggravated assault with a deadly weapon without the intent to kill. We would set his bond there in an amount of $7,500. Count 2, we do find probable cause for possession of a weapon or ammunition by a convicted felon. That bond would be set in the amount of $2,500. We would order he have no contact with the alleged victim in the ag assault case, no return to the location. He's also not to possess any firearms or weapons as a condition of his release, okay? Mr. Rodriguez Serrano, you do not qualify for a court-appointed lawyer, okay? You're not indigent. So you do need to hire your own lawyer if you choose to do so, okay?
I got a bond.
Yeah, your bond totals $10,000. Okay, and you'll get the paperwork on that, and you'll be able to bond out if you can, but you do need to talk to a lawyer, okay?
Yes, sir.
All right, good luck.
Thank you, sir.
This is Ms. Russell. Okay,
I have a PC argument with this
is
case.
she
Your
a
Honor.
co-defendant to,
Yes.
so 22 CF 14326, PC argument.
Yes, my argument is the same in regards to the robbery charge for the co-defendant, Ms. Clark, and also she was not located, well, Ms. Russell was not located in the store at the time of the offense.
But can I say something, please?
No.
It's probably not a good idea to talk about what happened here. If you have something to say, let her know. She's a trained lawyer. Okay? Who is this? This is Rasha. Okay, let's see.
And then also, I believe from this specific 7-Eleven location, nothing was found on Ms. Russell from this 7-Eleven. Yeah, but that's what they're just gonna.
And as to that case, any response from the state?
Yes, Your Honor. The affidavit does indicate that it appears this defendant was knocking on the front window in an attempt to distract the clerk. I do agree with the defense that she was not inside the store at the time. At most, she would maybe be an accessory. So we will leave it at this court's discretion as to bond.
Okay, I don't know if knocking on the window is sufficient to make her an accessory. It does appear, at least based on this report, she wasn't in the 7-Eleven, okay? So I would find no probable cause for the robbery or the petty theft as to the 7-Eleven. She could be released on her own recognizance as to that. The other case, which is 22 MM 8291, there would be probable cause for petty theft there. That bond would be set in the amount of $250. Order of no return to the Family Dollar on Goldenrod Road as a condition of release there. And we can appoint the Office of the Public Defender as to both cases. Okay? Thank you.
Your Honor, Jermaine Smith is a refusal.
Refusal, Jermaine Smith?
No objection to waiving, Your Honor.
Okay, we do find probable cause for battery on law enforcement officer, $2,500 bond. Also, one count of petty theft, a $250 bond, one count of battery, a $500 bond. We would order no contact with victims alleged, no return to the Wawa where the theft is alleged to have occurred, no contact with any other victim. And we can appoint the PD. Are you Mr. Thomas?
Yes, sir.
Mr. Thomas is here. We do find probable cause for one count of carrying a concealed firearm. Mr. Thomas' bond would be set in the amount of $2,500. We will appoint the Office of the Public Defender to represent you, okay?
Your Honor, I do understand that you just set bond. Do you have any objection to RR? He doesn't have any criminal history, no failure to appear, and no out-of-state criminal history or convictions.
Anything from the state?
The firearm was accessible. No objection to reducing the bond, but we would object to ROR.
He does have a stable home, phone number, and email, so when the court date is set, then he can come to court.
We can lower it to $1,000, but I think bond is important in this case. So we set bond at $1,000 with the condition that he not possess any weapons or firearms, okay? Good luck, thank you.
Yeah, this too.
All right, is this Mr. Bua? Your name is Bua? Bourgeois. Bourgeois, gotcha. Let's see what's going on here. What is going on here? Okay, we do find probable cause for driving with a license suspended or revoked. Subsequent offense, that's a $500 bond, and we can appoint the Office of the Public Defender to represent you with the condition that you do not drive without a valid license, okay? Thank you, sir. Good luck. Are you Miss Zarni?
Yes, I am.
Okay, Ms. Zarni, we do find probable cause for a DUI. We could set your bond in the amount of $500, and we will appoint the Office of the Public Defender to represent you. Okay? Thank you. Are you Mr. Johnson?
Yes, sir.
Okay, Mr. Johnson is here. I'm showing you had a warrant issued for missing a court date, failure to appear. The judge has given you a $1,000 bond, okay, and we can appoint the Office of the Public Defender to represent you, okay? Okay. Good luck.
Your Honor, Aguirre is a refusal.
Aguirre.
Defense has no objection to waiving his appearance, Your Honor.
Okay, so that's probable cause for trespass on property after a warning. Bond would be set in the amount of $500. We would order no return to the Florida Mall, and we can appoint the Office of the Public Defender. Donge Yashika Carter?
Don G.
Don G.
Yes, sir.
Okay. All right, we do find probable cause for one count of battery. And we would set bond in the amount of $500 and order no contact with Marshall Long as a condition of release.
Okay.
Y'all don't live together, do you?
No, sir.
Okay, so no contact. You're not to possess any weapons or firearms also as a condition of release. We will appoint the Office of the Public Defender to represent you, okay?
Okay.
Thank you.
What about my clothing? Will?
Is it over? Is that the?
At the hotel, yes,
Oh,
all of my clothing. I went over there Wednesday.
I'm sorry?
She got a one-time return with law enforcement to the hotel that they were at.
Yes, if there's stuff there, you can return one time with law enforcement to get your stuff, okay? Yeah, well, there would be no return to the location except.
Yeah, they don't live together. They don't live at that location, no.
No contact, correct. Are you Mr. Hemlock? Hemlock, okay. All right, Mr. Hemlock, I do find probable cause for one count of trespass after a warning. We can set your bond in the amount of $500. We can appoint the Office of the Public Defender to represent you, okay?
Is there any way I can get time served on this?
Yes.
Does he want to plead?
There is an offer to resolve this case, but he was just recently Baker Acted, so we do have competency concerns, so I'm not sure if we'll be comfortable with pleading him out.
Mr. Hemlock, how old are you, sir?
48.
48, and are you employed?
Currently looking.
Okay, when was the last time you worked?
I went to volunteer in Ukraine, but prior to that, I was working in July.
And what type of work did you do? Okay. And do you have a stable house, or are you moving around?
I'm being staying at the coalition.
Coalition, okay. And what is your highest level of education?
Almost graduating college.
Do you have any family in this area?
I do, yeah.
And who do you have?
My mother and my father.
And the competency concerns, raised by someone in your office, do you know the circumstances?
No, I just see that he was recently Baker acted. I didn't look
Okay.
further into it, Your Honor.
And how long ago do you know did that happen?
I can double check. I just didn't see.
It was recently. I just got out. I did my 72 hours there. I was having a rough morning. I was stopping traffic, basically taking my time across.
And how long ago did you get out?
I've only been out for two or three days now.
Do you take any medication?
I'm not. No, I haven't. They gave me a prescription. I still have it in my pocket and my stuff. I just haven't had a chance to get over to Princeton and Mercy.
Based off some of the statements made today, the state does also have competency concerns. And I think that it would be best that we have him seen by someone. I don't know.
Well, I mean, there's nothing I can do right now other than, he probably does he qualify for mental health PTR by any chance?
You can state to have him screened for mental health PTR.
Why don't we have him screened for mental health PTR, okay? And if he doesn't qualify, though, I'd like him to be brought back here to consider an ROR, but
May I speak?
Yes.
I just don't understand. I mean, I've had trespassings before, and it's always been a ticket. I've never been brought in before. I think it would be kind of absurd to keep me here for almost 33 days for this, which could happen because I'm not gonna bond out. The last time I was detained here, I spent 38 days out of my 33. Even though it's only gonna be $50, I'm not gonna rely on someone else or anyone to bond me out. I don't think that.
Well, are you able to bond out with a $500 bond?
You know what, I'm not gonna use my parents as my resource. They would be able to do it, but I'd be begging them for something. You know, I got myself in this trouble. I feel like that I need to get out myself. I don't feel like this is gonna be worth any of our time to keep me here for 33 days. Like I said, time served. I spent, for the last thing I got busted for, I spent 38 here because of the hurricane instead of 33, so I think that I at least have maybe some credit on this.
And do you know how long it takes to screen someone for mental health PTR?
5 days.
5 days?
Your Honor.
Can we reset it more than 24 hours or no? You can?
Well, And if we were comfortable, you could take a plea, I presume the state's offer would be time served?
Yes, Your Honor, that was the offer.
All right, we're gonna release you on your own recognizance today, okay? We'll see what happens with this, and that's about, I think, all we can do right now. I just don't know if it makes sense to have him screened, which means he'll be here for another 5 days, if you would be able to plea out today and go home, so just be careful. Good luck.
Thank you, I appreciate that.
Are you Mr. Hunt? Yes. Mr. Hunt is here. What do you have, Mr. Hunt? Case 22MM 8290. We do find probable cause for petty theft, and bond would be set in the amount of $250. We would order no return to the Family Dollar store.
In regards to his auto bond case, Your Honor, there was a notice of non-filing filed, so no information has been filed yet. Defense is asking that you take no action.
Okay, we'll take no action. We could point the PD on his new case, okay? Thank you, Mr. Hunt.
The bond out, 250.
Your Honor, Jordan is a refusal.
Okay, so his bond, we could set in the amount of $500 order for trespass on property after a warning, no return to the Wawa on South Orange Blossom Trail, and we can appoint the Office of the Public Defender.
Yes, Your Honor, no objection to a waiver.
Okay, thank you. Are you Mr., is it Reese Frith?
Yes.
Okay, Mr. Reese Frith. We do find probable cause for one count of battery. We can set your bond the amount of $500. Or do you have no contact with Ms. Nyasha Monroe? And you're not to possess any firearms or weapons as a condition of release, and we can appoint the Office of the Public Defender.
Can I get a bond reduction?
No.
My bond reduction?
No. You're fortunate it's 500. All right, are you Mr. Tritch?
Sir, I
All
am.
right, Mr. Tritch is here. Mr. Tritch, we do find probable cause for petty theft of $100 or more. It's case 22 MM to 8282. We're going to order you have no return to the Lowe's at 3500 South Cimarron as a condition of your release, and we will appoint the Office of the Public Defender, okay?
Sir,
Bond is stated $1,000, okay?
is it $1,000?
500, sorry,
500,
500.
so I just pay 100 to get out, sir?
$500, whatever the bondsman tells you to do.
Okay.
Okay, all right, thank you.
Your Honor,
I have a hold from Kentucky.
Billy D. Williams is medical.
Mike.
Mental health,
Medical.
medical. You want him to come back?
Yes, Your Honor, no objection to resetting it to tomorrow.
Okay, we can do that. Reset for tomorrow. Are you David Williams?
Sir.
All right, Mr. Williams, we do find probable cause for trespass on property after a warning.
Signed a plea form, Your Honor.
It's coming back tomorrow.
Do you want to play it now since he filled out the form, or do you want to wait till tomorrow?
I could, what's typically done? Just wait till tomorrow. Okay. Are we gonna work this out or not?
Yes, there's an offer, Your Honor. A no contest plea, adjudication of guilt, court cost, credit for time served. No return to the Wawa located at 2507 North Jongyang Parkway.
Can you raise your hand? Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and you told me you're David Williams, so you can put your hand down. And Mr. Williams, how old are you?
I'm 40 years old, sir.
And what is your highest level of education?
9th grade.
And are you able to read and write English?
Yes, sir.
Are you under the influence of any alcohol, drugs, or any medication?
Yes, sir.
Is there anything wrong mentally or physically that would interfere with your ability to understand what we're doing?
No, sir.
All right, so this is your plea form that was given to me. Did you read, understand, and sign this form?
Sir.
By entering a plea, you are waiving certain rights, and those are explained here. Do you understand that?
Yes, sir.
All right, and you're entering a plea of no contest to trespass on property after a warning, is that correct?
Yes, sir.
All right, I do accept your plea, Mr. Williams. It's freely and voluntarily made. You're alert, intelligent, understand what we're doing here, and are represented by competent counsel. We're gonna adjudicate you guilty. It's a time-served sentence, so you're able to go home. We do assess court costs, the amount of $223. We can reduce those to a civil judgment. That's the extent of your sentence, but I suggest you stay away from Wawa if they've trespassed you, otherwise you're gonna be right back here, okay?
All right, sir.
Okay, Prince, do I order that, or just happen? Okay, okay. All right, so you're gonna fingerprint you, okay? Good luck, you have 30 days to appeal.
All right.
Yes, we will. Are you Mr. Yates?
Yes, Your Honor.
Okay, Mr. Yates, we do find probable cause for one count of battery. We can set your bond in the amount of $500. We would order you have no contact with Allensworth Daniel as a condition of your release. I don't think they live together.
I'm sorry.
I don't think they know each other.
They don't know each other. Okay, so you'd have no contact with Mr. Daniel, $500 bond, and we will appoint the Office of the Public Defender to represent you, okay?
Yes, Your Honor.
Good?
Yes, Your Honor.
If you have a question, you can ask her.
One sec, Your Honor, I apologize. We're done, Your Honor.
Okay, are you Miss Duff? Miss Duff, okay. All right, Miss Duff,
I'll take off.
all right, so Ms. Duff has a warrant out of Hillsborough. It looks like the bond right now is $7,500. Okay, we can appoint the Office of the Public Defender here to represent her while she's here, but arrangements, if you're unable to bond out, arrangements would be made to get you to Tampa. Okay, if you're able to bond out, you need to check in with those folks, okay?
I think, is it 7,500 on one and none on the other, or just, from my understanding?
What does she have? She's got.
I see two.
Oh, oh, that's Hillsborough also? That's no bond because it's a VOP, so I'm sorry. So she'll have to be transported to Hillsborough.
Your Honor, I'm not sure if you want to set this for 24 hours for reset. She's alleging that on the warrant, it's not her. I don't have a copy of that warrant with me, Your Honor.
I don't mind. I mean, she's welcome to come back tomorrow if she's got something some way to show it's not her, but.
You'll be able to provide additional information.
I have the warrant affidavit in there.
If we reset it for tomorrow, we'll be able to figure out
So
whether
I
or
can
not
bring
it's
that
you.
warrant affidavit and show that that's not me?
Well, it may not be as easy as that, but you're welcome to come back and show the judge. I won't be here tomorrow. Show the judge whatever you want him or her to see, okay? But right now, what we have is Tampa says it's you and they want you back, okay? But I don't mind resetting it for tomorrow if it's gonna, might do someone some good.
Do you want to reset it for tomorrow? Won't really make a big difference.
No.
Okay, no, Your Honor, it's fine.
Okay, so it's the bond and the no bond, and then Tampa will be notified, Hillsborough will be notified, and they'll probably make arrangements to get you down there, okay? Good luck.
It's yours.
Are you Miss Fields? Okay, Miss Fields, let's see. So Miss Fields, you have a warrant out of Seminole County, it looks like. Right now it is no bond, okay? So we can appoint the Office of the Public Defender to represent you while you're here, but arrangements will be made to get you to Seminole County, okay?
You know how long that normally takes?
I think they have 72 hours to do that, okay?
Okay,
Thank you, good luck.
thank you.
Are you Mr. Peter LaRosa?
Good afternoon, Your Honor, yes.
Good afternoon. Out of county, Hillsborough, Mr. LaRosa.
Yes.
Right now, no bond. So you have two cases in Hillsborough. I think both are no bond right now.
Can you tell me the charges, sir?
One of them relates to domestic violence battery. Both of them do.
I only see one.
Okay, well, there may be a duplicate, but let me see.
Yeah, there should be only one, sir.
Okay, so it's one. That's one, the same numbers. Yeah, so it looks like it relates to domestic violence, but it'll be no bond. We'll appoint the public defender to represent you while you're here, but Hillsborough should make arrangements to get you back down there within 72 hours, okay?
Okay, sir.
Thank you.
Thank you.
Your Honor, Madame Gonzalez is medical.
Okay. Would you like to reset her? Was she reset from yesterday?
Yes, Your Honor, he was reset already, I believe.
We can
There's
reset.
an offer to resolve this case. We could do one last reset.
Okay, we can reset it. So who's next? Reddick?
Yes.
Are you Jada?
Jada.
Jada Reddick. So, Ms. Reddick, it looks like you're on probation, right? And there is a warrant for violating probation. Right now, it's no bond. And we can appoint the Office of the Public Defender to represent you, okay?
Yes, sir.
And they will know what to, she's got a second case that has a $2,000 bond. That's 21 MM6. So that case, she's got a bond of $2,000. The other case, it's no bond.
One moment, please, Your Honor. I apologize. She has a question. That's resolved. Your Honor, we're done.
Thank you. Good luck. Are you Mr. Jameson?
Yes, sir.
Okay, Mr. Jameson.
There is an offer to resolve this case. I haven't been able to speak to him, Your Honor. One moment, please.
Time.
I just need the case number, Your Honor, please.
22 MO1360.
Thank you. It's a withhold of adjudication, court cost, the filing fee, and credit for time served.
Your Honor, that's for both counts, and he can pay one court cost.
Mr. Jameson, can you raise your right hand? Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and you told me that you're Jaden Jameson. You can put your hand down. And how old are you, Mr. Jameson?
20.
20?
Yes, sir.
And how far have you gone in school?
Graduated high school. I'm going back to
Okay, where'd you go to high school?
St. Augustine in New Orleans.
Okay. You're able to read and write English?
Yes, sir.
Okay. Are you today under the influence of any alcohol, drugs, or any medication?
Yes, sir.
Okay. You're only 20 years old?
Yes, sir.
Really? You know, the drinking age in Florida is 21. You understand that, right?
Yes, sir. It is.
Okay, all right. This is your plea form here, okay? Did you review this and sign the plea form?
Is that what I that?
Yes, do you want me to go over?
This is the form that you had
No,
a minute ago. Did you sign this?
Yes, sir.
Okay. By entering a plea today, you are waiving certain rights, okay? They are explained here in the plea form. For example, you're waiving the right to have a trial and require the state to prove these allegations. You're giving that up, that right. Do you understand that? Has anyone threatened you or coerced you to do this? Okay. And you're entering a plea of no contest to one count of open container and one count of state.
It should be a resisting officer without violence, but it's like state misdemeanor.
One count of resisting without violence? Okay. Is that your plea today, no contest to open container and resisting without violence?
Yes, sir.
Okay. All right. And I do accept the plea. It's freely and voluntarily made. can do is adjudicate Mr. Jamison guilty. It's a time-served sentence. Is that right? And the
You have a withhold.
Withhold.
we're withholding adjudication. And what's the court cost? No, we don't need to do that. Okay. So 223 court costs, okay? We'll give you 6 months to pay that, okay? And you would pay it the clerk of the court. You can also pay it in Amscot if you have your case number. Mr. Jamison, do you have any questions?
No, sir.
Good luck. You have 30 days to appeal.
Thank you, sir.
There's also an offer to resolve this case as well, Your Honor. I just haven't had time to go over the offer with him. Okay. One second. Your Honor, there's an offer to resolve this case. I have comp concerns, and I do see something listed on his PTR paperwork. Do you have any objections to ROR him for the open container?
No, that's fine.
Yeah,
Okay.
that's fine.
Are you Mr. West, George West? Yes, sir. Okay. Mr. West, where do you live? Do you have a stable home, or are you moving around?
No, I don't.
No stable home? Okay. All right, we do find probable cause for the open container. We're going to release Mr. West on his own recognizance. Wish him well, okay? We can appoint the Office of the Public Defender to represent him on this. Thank you, Mr. West.
There's also an offer to resolve her case as well, Your Honor. I just need to speak to her.
Okay.
Okay. One moment, please. Your Honor, at this time, she's not accepting the offer to resolve her case. She does want to write this case, Your Honor. Do you have any objections to RRing her? She does not have any criminal history, no failure to appear, and it is a disorderly conduct.
I don't feel strongly one way or the other.
The state does not object to that, but the state would like, based off the disorderly is technically of resisting. Please don't get in any more trouble, because I don't want to get in trouble because you got RR. So no objection, but.
Well, you can object to it. I could still give, if you want to object, that's fine. I'll give it. She's Mr. Jamison's friend,
Yes.
Yes.
right? Okay.
Yes.
He's probably not, no man is worth getting arrested for, except under maybe limited circumstances. I'm half kidding on that, but I'm going to release you on your own recognizance. Be careful, okay? Good luck.
Ready.
No appeal appointment, right?
Do you want to be appointed?
It doesn't matter. I might not get her case.
I'd be shocked if I'd just be shocked if she got charged, but we'll see.
Yeah,
Yeah.
the city attorney will definitely handle that.
Thank you all.
Your Honor, we have, on the misdemeanor DV case for Persad, the victim showed up.
For who?
For Persad,
Oh.
Rush, just look it up. Hold on. PTR, no contact. Okay, so it's 22 MM 8293. For the record, we'll note we dealt with Mr. Prasad earlier today, so he's not in the courtroom. But the alleged victim is here and we can talk to her. Can you raise your right hand, ma'am? Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, and get close to the microphone so we can hear you.
Yes, I do.
And what's your name, please?
My name is Jerry Montero.
And what is your relationship with Mr. Prasad?
He's my fiance.
And when I saw him earlier, I ordered that he have no contact with you. Would you like to have contact with him?
Yes, sir.
Okay. Has anything like this, where he's been violent with you, ever happened before?
He is not a violent man, Your Honor.
Okay.
He is a law-abiding citizen. He's an outstanding
That probably
citizen.
didn't answer the question, though. Has he ever
No.
been violent with you before?
No, sir.
Okay. Are you in fear of him?
I am not.
Okay. Do you all live together?
We don't.
Do you have children together?
No, sir.
Okay. Does the state have any questions?
No questions, Your Honor.
So what we can do is delete the no contact, and we're gonna order no hostile contact, but everything else would remain the same. So he's allowed to go home, or he's allowed to see you, but we're gonna order he have no hostile contact with you, okay?
Absolutely.
All right, thank you.
Do you still want to keep the no weapon?
Thank you.
Yes.
Can
Everything
I
else?
say anything else?
No, they don't. Yeah, well, they don't live together, I think, but no, they can live together. It's just no hostile contact, so they don't have to maintain separate residences.
All right, I'm ready to get started now.
Yes, Your Honor.
All right. Would everyone please raise your right hand? Do you swear or affirm that any information that you tell the court today will be the truth? If so, say I do. All right, you can lower your hands. Thank you. This is your first appearance in the Magistrate Court of Clayton County. I'm here to let you know what you've been charged with, what your bond amount is if you have a bond set, and to let you know what your rights are as it pertains to this case that we're doing today. You all have the right to the presumption of innocence and have the state to prove your guilt beyond a reasonable doubt. You have the right to indictment by grand jury and accusation if you're charged with a misdemeanor. You have a right to a speedy and public trial. You have a right to see, hear, and cross-examine all witnesses that are called to testify against you. You also have the ability to compel witnesses on your behalf to testify for you. You also have the right to have an attorney to represent you throughout the entire proceedings. Some of you will be allowed to post what we refer to as unrestricted bonds, meaning that you'll be able to post your bond by going through a bonding company, by posting the cash directly to the jail, or by using real property. If you decide you want to go through a bonding company, they charge about 15% to secure your release from custody. So for example, if your bond is $1,000, the bonding company will take approximately $150 to secure your release. If you decide that you want to use real property, it has to have 3 times the amount of equity in the property to use it. So if your bond is $1,000, that property would have to have $3,000 worth of equity in order to secure your release. You can also post the cash directly to the sheriff's office. If your bond is $1,000, you will post the entire $1,000 directly to the sheriff's office. At the end of the case, that money would be returned to you minus some administrative fees. Some of you will have what we refer to as special conditions that have been placed on your bond, which means that I will ask you not to have contact with a certain person as a condition of being granted bond. I may also ask you not to return to a certain location as a condition to being granted a bond. If you decide that you are going to violate the court's order and have contact with a person that I've asked you not to have contact with or return to a location that I have prohibited you from returning to as a condition of being granted bond, you could be charged with aggravated stalking, which is a felony, and you may not be entitled to a bond throughout the duration of your case if you are charged with aggravated stalking for violating a judge's bond condition. The next court that you will get is what we would call a preliminary hearing. So if you are unable to, for whatever reason, you can't make your bond, you don't have a bond, that's the next time that you will be before a judge about this case. If you are charged with a misdemeanor, that court date would be November the 29th. And if you are charged with a felony, that court date will be November the 30th. If you make your bond, you do not have to come back to court on those dates that I just announced. You will receive notice in the mail when to come back to court. With all that being said, we'll get started with the females. The first person that I have is Adelaja Joyce.
All right, all the men, step back in.
What's Joyce? Go ahead, step up in front of me. State your name for the judge, please. Joyce Adelaja.
Yes, ma'am, you've been charged with simple battery. Your bond is $1,000. Public drunk is $1,000. Simple battery on police officer is $1,000. And obstructing a law enforcement officer, that bond is $1,000. Your total bond is $4,000. As a condition of bond, you cannot have any contact with Chelsea Lee. Your next court date, if you don't make your bond, is November the 29th. And based on the form that I've received, you have refused to complete it. So either you intend to hire your own attorney or represent yourself. Do you have any questions?
No, ma'am.
All right, thank you. Ms. Blackwell? All right, Ms. Blackwell, you've been charged with criminal trespass. That bond is $1,000. You can't have any contact with Tanika Blackwell. Do you understand that, ma'am?
You said I can't have contact?
No, you cannot have contact with Tanika Blackwell as a condition of your bond based on the allegations. Do you understand that?
Yes, ma'am.
Your
You said it's
preliminary hearing date is on November the 29th. And based on your application, I have appointed an attorney to represent you. Do you have any other questions?
No, ma'am.
All right, thank you.
You said it's 1,000?
Yes, ma'am.
This one. Next one.
All right, Ms. Hurd, you've been charged with DUI, alcohol left safe. That bond is $3,000, and speeding is $500. Your total bond is $3,500. Your preliminary hearing date is on November the 29th at 8:30 a.m. I don't have any information on your form to be considered for a court-appointed attorney. Did you want to be considered for an attorney today?
Yes.
How much money do you earn a month if you work? Are you employed?
Yeah.
All right, how much do you earn approximately every month?
I'm probably around like 2,500.
You said 925?
2,500.
I can't hear you.
2,500.
All right, based on that information, I have appointed an attorney to represent you. Do you have any questions?
No.
All right, thank you. Ms. Powell? Ms. Powell, you've been charged with improper lane change. That bond is $500. Violation of Georgia Controlled Substance Act is $3,000. Your preliminary hearing date is on November the 30th if you're unable to make your bond. Based on your application, I have appointed an attorney to represent you. Do you have any questions?
No.
All right, thank you. Are you Miss McCoy? Ms. McCoy, you've been charged with DUI, alcohol, let's say. That bond is $3,000. Your preliminary hearing date is on November the 29th if you don't make your bond. If you make your bond, you'll get notice when to come back to court. Based on your application, I have appointed an attorney to represent you. Do you have any questions?
Yes, in lieu of the bond would be an issue for me, not having anyone. There's no way I could do weekends, ma'am, I have to work and I have to be to work with less than 24 hours. I'm not gonna find out and.
So, this is just your first appearance, so we don't resolve anything at first appearance. You see, there's nobody here. There's no prosecutors, no police officers, nothing. So I just let you know what you're charged with. I have appointed you an attorney to see if they can possibly get it resolved sooner than later. They have to come visit you in the earlier part of this week. So if you're unable to make your bond, your attorney will be there this week in the beginning part of it to see what they can do to help you out.
Okay, and you said that bond was, what was the amount, ma'am?
It's $3,000. All right, thank you. Are you Ms. Stewart?
That's Sam, Your Honor.
That's yeah, I'm gonna do all the fugitive cases at the same time, if that's not a problem.
Okay, we can get Ms. Stewart.
Okay.
Okay.
Stewart. Okay, step back, yeah. Okay, we got Miss Stewart, Your Honor.
All right, Ms. Stewart, you've been charged with speeding. Your bond is $500. License driving while it's suspended is $1,500. And violation of the Georgia Controlled Substance Act is $3,000. Your total bond is $5,000. Your preliminary hearing date is on November the 30th. Based on your application, I've appointed an attorney to represent you. If you decide to hire one, you can do so at your own leisure. Do you have any questions?
So to leave today is 5,000.
The total bond, yes,
Okay.
All right, any other questions?
No, that's it.
All right, Ms. Sal? Yeah, I'll go ahead and do it since you don't have to mix her up with the mail. Ms. Sal, all the rights that I explained to everyone else also apply to you in your case. The only difference is you don't have any charges pending in Clayton County. You were brought to court today because you have charges pending against you from a different state. You are wanted out of Oconee Sheriff's Office in South Carolina, warrant number W7339-48906. So you've been charged with being a fugitive from the state of South Carolina. You can contest your extradition, or you can decide that you want to waive it and voluntarily return to South Carolina on your own, without going through the formal extradition process. If you decide that you want to contest your extradition, you'll be committed to the Clayton County Jail for an initial period of 30 days, during which time a warrant will be prepared with the governor's signature for your extradition back. The court may consider allowing you to post a bond. At this time, the court is not granting a bond. If you do not wish to voluntarily return, you can file a writ of habeas corpus to contest your extradition. You can contest whether the documents are valid on their face, whether you're charged with a crime that actually exists in South Carolina, whether you're in fact the person named in the request, and whether you're in fact a fugitive from justice. You cannot contest your innocence or guilt in the state of Georgia. You can waive your extradition process and voluntarily return. I can't in fact tell you what date by the when they'll actually come and get you, as a number of things affect that. So are you in fact Sandrika Michelle Sapp?
Yeah.
All right. Do you already have an attorney representing you for this? Okay. Do you want to contest your extradition, or would you like to waive it and voluntarily return?
Like the voluntary return, I guess. Oh, yes.
Okay. All right. So there have the forms. They're called waiver extradition forms over there. You'll need to sign all of those forms for legal reasons. And once they're signed, they'll send them to South Carolina, and then they'll come and pick you up, and you will no longer be in Clayton County Jail. Do you have any questions, ma'am?
Once I sign these papers, that's for me to go, right?
Yep.
The papers for me. That's it.
Okay. All right. Thank you.
I get paper too. Your Honor, we do have some Hispanic males that need an interpreter. Do you want to go ahead and save them for last?
Yes.
Okay, give me one. All right, Your Honor, we're ready. Okay.
All right. Mr. Adams?
Adams. 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 Come on up.
All right, Mr. Adams, you've been charged with theft by receiving stolen property. Your bond is $5,000. You've been charged with violation of driving without a license. That bond is $1,000. So your total bond is $6,000. Your preliminary hearing date is on November the 30th. Based on your application, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you, sir. Mr. Jackson?
Jackson, I'm back in the, going where you were.
Mr. Jackson, you've been charged with terroristic threats or acts. Your bond is $5,000. As a condition of your bond, you can't have any contact with Jasmine Parker Carter. You cannot return to 950 Lake Ridge Parkway in Riverdale, Georgia, 30296. Do you understand the conditions of your bond?
Yes, ma'am.
Your preliminary hearing date is on November the 30th. If you don't make the bond, you, I guess, refuse to fill out this application, so you intend to represent yourself or hire your own attorney, is that correct?
Yes, ma'am.
All right, thank you. You have any questions?
No, ma'am.
All right, thank you.
Hold on. Mr. Adams, come over here. Hold on.
All right, Mr. Jones?
John? Jones. Jones. Jones.
All right, Mr. Jones, you've been charged with battery. That bond is $5,000. Cruelty to children in the third degree is $1,000. False imprisonment is $10,000, and aggravated assault is $25,000. So your total bond amount is $41,000. As a condition of your bond, you can't have any contact with Ravonda Stocks. You cannot return to 6726 B1HA Terra Boulevard, Jonesboro, Georgia, as a condition of bond. If you are released from custody and you have undisputed personal property, you can go with the deputy within 10 days from your release from custody to retrieve undisputed personal property. Do you understand the conditions of your bond?
Yes, ma'am.
All right, your preliminary hearing date is on November the 30th. Approximately how much money do you make a month?
I like I do maintenance at the job.
I didn't hear you. How much do you make approximately a month?
I like 4,000 a month, maybe.
All right, based on that information, I'll appoint an attorney to represent you. Do you have any questions, sir?
You can give me the price of the amount, 41,000 again?
Yes.
41,000.
All right, thank you. Joseph Lee?
How you doing, man?
All right, Mr. Lee, you've been charged with cruelty to children. That bond is $5,000. Simple battery is $5,000. Aggravated assault, your bond has been denied. Terroristic threats is $5,000. Interference with custody is $5,000. Entering an automobile is $10,000, and kidnapping, that bond has been denied. Your preliminary hearing date is on November the 30th. Your bond hearing date, if you don't have one resolved on that date, will be December the 2nd. Based on your application, I have appointed an attorney to represent you. Do you have any questions?
So I couldn't bond out now.
No, because you got two of them where you don't have a bond set yet.
Excuse me?
You have two charges, the aggravated assault and kidnapping, which you don't have a bond set yet. So you're not gonna be able to bond out because you don't have a bond on those charges. Did you have any other questions?
What's the total for the other charges?
30,000.
That's for all of the other charges, 30,000?
That's the total for all the rest of them.
Okay. Thank
All right, thank you.
I've seen it 7.
This is Lori, Your Honor.
7, yeah, all the way down.
Alan. Step up on the circle here, sir. State your name for the judge.
McClay, Richard Ricardo.
What's your name, sir?
John Larry.
All right, Mr. Larry, you've been charged with entering, with burglary. Your bond is $30,000. As a condition of your bond, you cannot return to the Corn Laundry located at 905 Forest Parkway in Forest Park, Georgia. Do you understand that, sir?
Yes, ma'am.
Your preliminary hearing date is on November the 30th. So, let's see, where's your form? Based on your application, I have appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
My bad.
You said what?
So like when I do burn out, like how much it is, how much percentage it would be, like you said, 30?
It's gonna be about 15%, so anywhere between $3,500 to $4,000, depending on which bonding company you use.
Yes, ma'am.
All right, thank you.
Go ahead. Stand in front of that window there, sir. Step on that circle.
All right, are you Mr. McLeod?
Harry.
You've been charged with driving without a license. That bond is 1,000. Red light violation is 500. Terroristic threat to act is 3,000. So your total bond is $4,500. Your preliminary hearing date is on November the 30th. Based on your application, I have appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
Join behind him. Step up. State your name for the judge, please. Next person.
There you go.
What's your name?
Harry McHale.
Mr. McHale, you've been charged with loitering and prowling. That bond is 1,000. Concealing a tag is 500. Use or possession of drug-related objects is 500. 2 counts of violation of the Georgia Controlled Substance Act is 3,000 each count. And driving with no insurance or having no insurance on a vehicle is 1,000. Your total bond is $9,000. Your preliminary hearing date is on November 30th. Based on your application, I've appointed an attorney to represent you. Do you have any questions?
10 or 15%, like
Do you have any questions, sir?
No.
All right, thank you.
Tony.
Tony?
What's your name, sir? All right, Mr. Morris, you've been charged with obstructing a law enforcement officer. That bond is $1,000. Your preliminary hearing date is on November the 29th. Based on your application, I've appointed an attorney to represent you. Do you have any questions? All right, thank you. Are you Mr. Wynn?
Phillips.
Are you Mr. Wynn?
Yes, ma'am.
All right, you've been charged with distracted driving. That bond is 500. 2 counts of violation of the Georgia Controlled Substance Act is 3,000 each count. Possession or use of drug-related objects is 500. Improper lane change is 500. and DUI alcohol left safe is $3,000. Your total bond is $10,500. Your preliminary hearing date is on November the 30th. If you don't make your bond, if you make your bond, you don't have to come to court on that date. You will get notice in the mail when to come back to court. From my understanding, you refuse to complete the application form, so you intend to represent yourself or hire your own attorney. Is that correct, sir?
Yes, ma'am.
All right. Do you have any questions?
No, ma'am, thank you.
All right, thank you.
Ms. Allen.
McCoy.
What's your name, sir?
Is it Philip?
Stand in front of the window here. To the right, all the way to the right.
All right, we're gonna do all the fugitives last. Mr. Phillips, if you can just step to the side, we'll take care of you. And then all the rest of the people charged with being a fugitive.
Okay, LaCory,
You can go ahead and step.
Redfern.
aside, sir.
Okay, what's your name, sir?
Yeah. Philip, Baker, and Seth.
All right.
Philip, Baker, and
Mr. Rouse, you've been charged with battery, family violence. That bond is $10,000. Criminal damage in the first degree is $10,000. Reckless conduct is $10,000. And aggravated assault, your bond has been denied. Your preliminary hearing date is on November the 30th. Your bond hearing date, if they're unable to do a consent bond on that date, will be December the 2nd. Based on your application, I'm appointing an attorney to represent you. Do you have any questions? All right, thank you.
And right behind him.
All right, are you Mr. Redfern?
Yes, ma'am.
All right, so you've been charged with criminal trespass. That bond is $3,000. You cannot go back to 9727 Terra Boulevard in Jonesboro, Georgia, 30236. Do you understand that, sir?
Yes, ma'am.
Your preliminary hearing date is on November the 29th. Based on your application, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
Stand behind him.
Shavers.
Shaver.
All right, are you Mr. Scarver?
Ma'am.
All right.
Auditor Central, let me get CS1, please. And then
Mr.
one
Scarver,
for
you've been charged with failure to obey a directing traffic device. That bond is $500, and driving with a suspended or revoked license is $1,500. So your total bond is $2,000. Your preliminary hearing date is on November the 29th. Are you currently employed?
Yes, ma'am.
How much do you earn a month approximately?
I'll say about a month, about 2,600.
All right, based on that information, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you, sir.
Thank you.
All right, are you Mr. Shavers? Mr. Shavers, you've been charged with violation of the Georgia Controlled Substance Act. Your bond is $3,000. Your preliminary hearing date is on November 30th if you don't make your bond. Based on your application, I have appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you, sir.
Taylor, step on up. Who's after Taylor? Step on that circle, state the name for the judge. Who's after Taylor?
Hey, how you doing?
They don't know where to go or something?
All right, are you Mr. Taylor?
No.
Mr. Taylor, you've been charged with theft by taking. That bond is $10,000. As a condition of bond, you can't have any contact with your previous single. Do you understand that, sir?
Yes, ma'am.
Your preliminary hearing is on November the 30th.
Oh, they don't know how to get it.
If you you didn't fill out this form, so are you gonna hire your own attorney or are you gonna represent yourself?
Hire an attorney.
All right, based on that information, you're responsible for hiring your own attorney. One would not be appointed on your behalf. Do you have any questions? All right, thank you.
Step up to the
And
circle,
Van.
stand in front of one on right, sir, always one. I'm
Van.
sorry. Van.
Are you Mr. Thornberry?
Yeah.
You've been charged with battery. That bond is $4,000. As a condition of bond, you can't have any contact with Luciano Benihandanti. Do you understand that condition?
Yes, ma'am.
Your preliminary hearing date is on November the 29th. And I assume you intend to hire your own attorney and represent yourself. I don't have any information on the form. Is that correct?
Yes, ma'am.
Okay, all right. Do you have any questions?
No, ma'am.
All right, thank you.
Yeah.
All right, are you Mr. Van?
Walker.
All right, Mr. Van, you've been charged with speeding. That bond is $500. Possession of marijuana less than 1 ounce. That bond is $1,500. So your total bond is $2,000. Your preliminary hearing date is going to be on November the 29th. And it looks like you intend to represent yourself, or you're going to hire your own attorney. Is that correct? All right, based on that information, I will not appoint an attorney to represent you. Do you have any questions? All right, thank you, sir. All right, are you Mr. Walker?
Yeah.
Mr. Walker, you've been charged with possession of a firearm by a convicted felon. That bond is $10,000. Possession of marijuana less than 1 ounce is $1,500. Obstructing a law enforcement officer is $1,000. Loitering or prowling is $1,000. And reckless conduct is $5,000. So your total bond is $18,500. Your preliminary hearing date is on November the 30th. Based on your application, I've appointed an attorney to represent you. Do you have any questions? All right, thank you.
Go ahead, go behind him. His name, Alan.
Adolfo.
Adolfo?
All right, are you Mr. Williams?
Yes, how you doing?
All right. Mr. Williams, you've been charged with speeding. That bond is $1,500. DUI, alcohol less safe is $3,000. Reckless driving is $1,500. Improper lane change is $500. And driving without a license is $1,000. Your total bond is $7,500. Your preliminary hearing date is on November the 29th. Based on your application, I'm assuming you intend to represent yourself or hire your own attorney. Is that correct?
Correct.
All right, based on that information, I will not appoint an attorney to represent you. Do you have any questions?
No.
All right, thank you.
Stand to the right in the window, sir.
All right, so
Your
we
Honor,
can
this
do Mr. Phillips and Mr. Baker, and then we'll do all the Spanish-speaking people together. I have to call the language.
Your Honor, when you called Joseph Lee, I think we skipped over Adolfo Lopez. He doesn't need an interpreter.
All right, Mr. Lopez, you understand English, is that correct, sir? I'm sorry, I didn't hear you. All right, you've been charged with fleeing from a police officer. That bond is $3,000. Reckless driving is $3,000, and driving without a license is $1,000. So your total bond is $7,000. All right, so you've also indicated that you're going to either represent yourself or hire your own attorney. Is that correct? All right, your preliminary hearing date is November the 29th. If you don't make your bond, do you have any questions, sir?
Amen.
All right, thank you.
Go back in 11. I got it, 11. Yeah. And.
So now can we do Baker and Phillips?
Okay, we got Mr. Phillips, Your Honor.
All right, do you have Mr. Baker? Yeah, there we go. No, they can just stand side by side so I can read this at one time to both of them. All right, so both of you are now having what we call an extradition hearing. All of the rights that I advised everyone else apply to you just as well. But the only difference is you don't have any charges pending against you in Clayton County. You've been charged, Mr. Baker, with being a fugitive from justice. You are wanted in Marion County Sheriff's Office, California, for cruelty to animals. Warrant number W 486781308, which is a felony, which was indicated that they would extradite. And Mr. Phillip, you were wanted from Jefferson Parish Sheriff's Office in Louisiana for larceny, warrant number B 1133-120, a felony, which was also indicated that they will extradite. If you decide that you want to contest your extradition, you'll be committed to Clayton County Jail for an initial period of 30 days, during which time a warrant will be prepared with the governor's signature to prepare for your extradition. The court may consider allowing you to post a bond, but at this time, both bonds have been denied. If you do not wish to voluntarily return to the state that is demanding for you, you can file a petition of writ of habeas corpus to contest your extradition. You can test whether the extradition documents are valid on their face, whether the crime that you're charged with actually exists in the demanding state, whether you are the person named in the extradition request, and whether you are in fact a fugitive from justice. You cannot contest your innocence or your guilt inside the state of Georgia. You can waive your extradition and voluntarily return. I can't tell you how many days exactly they'll come, but I know if you waive it, it expedites the process. Are you in fact David Phillips, sir?
Yes, ma'am.
All right, do you already have an attorney representing you for this?
No, ma'am.
Do you want to contest your extradition, or did you want to waive it and voluntarily return?
Returning.
All right, sir, they'll have the forms there, Mr. Phillip. It's a number of them. You have to complete all of them for legal reasons. Once we get those, we'll forward them to the state that's requesting you in Louisiana, and they'll begin the process to come pick you up. All right, Mr. Baker, are you in fact Koshan Dion Baker?
Yes, ma'am.
Do you already have an attorney that's representing you in this?
No, ma'am.
Do you want to contest your extradition, or would you like to waive it?
I'd like to waive.
All right, likewise, they have a number of forms, the same exact forms in duplicate. You'll need to sign each one of them for legal reasons. As soon as those forms are signed, we'll get them back to California so they can start the process to extradition. Did you have any questions, sir?
I was aware that I had like two extraditions, one from Louisiana as well.
The only one that I have paperwork for is California. I don't have anything on Louisiana.
If you're aware, if I have two of them, if California doesn't pick me up, well, you said I will be extradited. So, will I have to start the process?
They've already contacted California, and they said that they will come and pick you up.
All right.
All right.
Appreciate it.
All right, you're welcome. All right, I got called a language line for the remaining Latino inmates. So I'm gonna put this on pause until I get them on the line, and I'll call right back.
Yes, Sean.
All right.
I will send you the waivers in the meantime.
All right. Would everyone please raise your right hand? Do you swear or affirm that any information you give the court today will be the truth, and so say I do? All right, you can lower your hands. All right, this is your first appearance in the Magistrate Court of Clayton County. We're not here to take a plea or to have a trial in your case today. I'm here to let you know what you've been charged with and what your bond amount is. I'm also going to let you know when your preliminary hearing date will be. You have the right to remain silent. You have the right to the presumption of innocence and to have the state prove your guilt beyond a reasonable doubt. You have the right to the indictment by grand jury. You have the right to an accusation if you've been charged with misdemeanors. You have a right to a speedy and public jury trial. You have the right to see, hear, and cross-examine all witnesses called to testify against you. You have the right to compel the attendance of witnesses to testify on your behalf. You also have the right to have an attorney represent you at all stages throughout this proceeding. Some of you will be allowed to post unrestricted bonds, meaning you'll be able to post your bond either cash through a bonding company or by using real property. If you decide that you want to use a cash bond and post it directly to the sheriff's office, that's exactly what it means. So for example, if your bond is $1,000, you will post the full amount of $1,000 directly to the sheriff's office. At the conclusion of your case, that money would be returned to you minus some administrative fees. You could also go through a bonding company. They take about 15% of what your bond amount is. So if you, for example, again, if your bond is $1,000, then the bonding company would charge you approximately $150 to secure your release from custody. That's the money that they make to actually post a bond on your behalf. If you have real property, you can also use that to secure your release from property. For example, again, if your bond was $1,000, you would have to have $3,000 worth of equity in the property to use it to secure your release. Some of you will have special conditions on your bond, which will prohibit you from contacting a certain person or returning to a certain location. If you disobey the court's order and you have contact with a person that I've asked you not to have contact with as a condition of being granted bond, or you return to a location that I asked you not to return to as a condition of getting bond granted, you could be charged with aggravated stalking, which is a felony. And if you're charged with aggravated stalking, which is a felony, you are not entitled to bond and could remain in custody for the duration of your case. So please keep that in mind, to not have contact with a person that I asked you not to have contact with as a condition of bond, and not to return to a location that I ask you not to go to as a condition of being granted bond. The next time that you will be in court, if you do not make your bond, or if you're unable to make it for whatever reason, if you are charged with a misdemeanor, that court date will be on November the 29th. If you are charged with a felony, the next time you will be in court about your case will be November the 30th. If you make your bond, you do not come to court on that date. You will receive notice in the mail when to come back to court. With all that being said, we'll get started with the first person. I have Amber Barber.
Barber?
Hold on. Put them back.
Oliver, sir. Oh.
Hey, Barber? Barber? Hey, Judge better see you. Judge better see you here. It's right there in front of the bench.
Ms. Barber, you've been charged with disorderly conduct. Your preliminary hearing date is on November the 29th. Your bond is $1,500. And from my understanding, you didn't want to complete the form so that I can consider appointing you attorney. So either you'll represent yourself or you have to hire your own attorney. Do you have any questions, Ms. Barber?
Am I getting released or am I serving time in jail?
Okay, do you have any other questions?
No.
Okay, thank you, Ms. Barber.
Private attorney?
You said you want an attorney?
Yes.
All right, are you employed?
No.
All right, I've appointed you an attorney. Thank you, ma'am.
Thank you. Am I staying in jail? I'm not sure.
No.
All right, are you Ms. Brooks?
Yes, ma'am.
Come on, we gotta come
Ms.
up
Brooks,
with
you've been charged with reckless conduct and firing, discharging a weapon. Your bond on reckless conduct is $5,000. The firearms discharge is $5,000. Your total bond is $10,000. Your preliminary hearing date is on November the 29th at 8:30 a.m. in the morning. Based on your application, I've appointed an attorney to represent you. Do you have any questions? All right, thank you.
All right, Cook.
Cook,
Ms. Cook, you've been charged with battery. Your bond is $4,000. You can't have any contact with Ms. Walker as a condition of your bond. You cannot go back to 3970 Scott Drive, Forest Park, Georgia. If you have personal property there, you can go with a sheriff's officer within 10 days from your release of custody. Do you understand the condition of your bond?
is it possible I could get community service? Can I
Yeah,
get community
yeah,
service?
maybe at a future day, but today is not a trial or a plea. I'm just here to let you know what you've been charged with. So that may happen
Okay.
at a later date.
You said it's Tiffany Walker or Salisha
Yeah.
Natika?
Your
It may-
grandmother.
Oh,
Yeah, do you
okay.
know what this is about? This is when you allegedly kicked and hit your grandmother about the hair?
I didn't do that. It was
No,
for Talisha.
I hear what you're saying. I'm sorry, Miss Cook, we both can't talk. So these are only allegations. I wasn't there. I don't know whether they're true or not. You're presumed innocent. Next time that you'll be in court to address this to be on 29th if you don't make your bond. I've appointed an attorney to represent you. Do you have any questions?
Oh, man.
All right, thank you.
Smart.
All right, Ms. Clark, you've been charged with loitering or prowling. That bond is 1,000. Criminal trespass is 500. Open containers, 500. Obstructing a law enforcement officer is $500. So your total bond is $2,500. As a condition of bond, you cannot go back to the Lovejoy Park located at 1935 McDonough Road, Hampton, Georgia, 30228. Do you understand the condition of your bond? Your preliminary hearing date is on November the 29th at 8:30 a.m. If you make your bond, you don't have to come back to court on that date. You'll get notice in the mail. Based on your application, I've appointed an attorney to represent you. Do you have any questions? All right, thank you.
Your Honor, are you aware that we need a Spanish interpreter for one of the females?
No, I didn't know it was for a female. Which one?
It's for a Lopez, Guadalupe Lopez.
Okay,
Spanish interpreter.
we'll do her last.
Yes, ma'am. All right, we have Edmonds.
Are you Miss Edmonds?
Yes, ma'am.
Miss Edmonds, you've been charged with speeding. That bond is 500. Possession of marijuana less than 1 ounce is 1,500. Violation of the Georgia Controlled Substance Act is 300. And possession or use of drug-related objects is 500. So your total bond is $5,500. Your preliminary hearing date is on November the 30th. And how much, I can't understand it. How much money do you earn a month?
About 4,000.
Okay. Based on that. Okay. All right. Based on that information, I'll appoint an attorney to represent you. Do you have any questions?
No, ma'am.
All right. Thank
you.
Are you Miss Mann?
Yes, ma'am.
All right, Ms. Mann, you were charged with battery. The officer did not complete the paperwork correctly, so based on that, your charge has been dismissed. But I want to caution you that the solicitor's office will probably charge you later when they correct everything. So just be aware of that. But for purposes of today, your charge is dismissed.
So I'll be going home?
Yes, at some point today or tomorrow.
Thank you.
You're welcome.
Go ahead, step up.
All right, are you Miss Meadows?
No.
What's your name?
Oh.
Shayla Peel.
I'm about to get metal.
Metal.
All right, are you Miss Meadows? All right, Miss Meadows, you were charged with battery. The officer in your case did not complete the paperwork correctly. So based on that technicality, I have to dismiss the charge today. I would like to caution you that the solicitor's office, when this happens, they go back and correct the paperwork and charge it correctly, which I anticipate they will do. But for purposes of today, your charge has been dismissed and you'll be released from custody sometime today or tomorrow.
Come on, bro.
All right, Ms. Peel. Ms. Peel, you've been charged with following too closely. That bond is $500. Driving with a suspended license is $1,500. No insurance is $1,000, and driving with suspended or canceled registration is $500. Your total bond is $3,500. Your preliminary hearing date is on November the 29th. If you make your bond, you don't have to come to court the date. You'll get notice when to come back to court in the mail. Based on your application, I have appointed an attorney to represent you. Do you have any questions?
You said if I make the bond, I don't go to court on the 29th.
That's
Is that
correct.
what you just
You'll get, they'll mail you notice when to come back to court. If you're still in custody, that's the next time you'll be in court. Do you have any other questions?
No, I guess not. Thank you.
All right. Are you Phillips? All right, Ms. Phillips, you've been charged with criminal trespass. Your bond is $2,000. Ms. Phillips, you cannot go back to 4853 Jonesboro Road in Forest Park, Georgia, 30297. Do you understand the condition of your bond? Your preliminary hearing date is on November the 29th. Based on your, how much money do you earn a month, Ms. Phillips? You didn't put that on the phone.
Wilkins.
Miss Phillips, Ms. Phillips, how much do you work, Ms. Phillips?
Absolutely.
How much money do you earn a month, Ms. Phillips?
It's not a month, it's annual. I don't know, give or take, it's over 100,000 annual.
All right. All right, thank you, Ms. Phillips.
Go ahead, step up.
All right, are you Ms. Wilkins? All right, Ms. Wilkins, you've been charged with driving while distracted. That bond is $1,000. Reckless driving is $1,500. Speeding is $1,500, and theft by receiving stolen property is $3,000. So your total bond is $7,000. Your preliminary hearing date is on November the 30th. Based on your application, I've appointed an attorney to represent you. Do you have any questions? All right, thank you.
Nothing.
All right. Okay, Your Honor, we're gonna start bringing out the mails.
Okay. All right, are you Mr. Grieve? All right, Mr. Grieve, you've been charged with criminal damage to property in the first degree. That bond is 1,000. Cruelty to children in the third degree is 1,000. Hit and run is 1,500. Driving with a suspended or registration or canceled registration is 500. A second count of criminal damage in the first degree is 1,000. Hit and run is 1,500, and cruelty to children in the third degree is 1,000. So your total bond is $6,500. As a condition of your bond, you can't have any contact with the interior gates. You cannot return or go back to 2608 Berkshire Road, Monroe, Georgia. And if you have personal property there, you have 10 days from your release from custody to go with the sheriff's officer to retrieve any items that are undisputed. Do you understand the condition of your bond?
Yes, but can I ask you a question?
Yes, what's your question?
At the scene, right? You saying you get me for a hit and run, but I never left the scene, no. I was right there sitting on the car with her, waiting on the police to get there. And then the suspended registration, I just came from South Carolina. I never moved that car. When that car sat there, the only car I was driving was my baby mother's car.
Okay, Mr. Grieve, I thought you actually had a question. So as I stated earlier, like you see, there's nobody here, there's no police officers, witnesses. So all of that can be disputed at a later date. Today is just about bond and the condition of your bond. So I need you to understand the condition of your bond. You understand how you can't have contact or go back over there until this bond is changed? All right, so do you have any questions?
Can I pay? I don't have anybody to sign, but I have money on my books. Can I bond out with the money I have?
So I've appointed a lawyer to help you with that process so they can get you bonded out. So they'll meet with you to help you get that taken care of, to get your money so you can make your bond. Do you have any other questions, sir?
No, but it's not the full amount, though. It's only a percentage of it.
Through a bonding company, it is.
I don't have nobody on the outside to sign or anything like that.
Yeah, so that's what so those questions you have to ask your lawyer to see how they can help you navigate that.
So when did I talk to them?
When they come to the jail to meet with you?
When would that be?
I don't have their schedule, sir. I don't know. I'm here on Saturday. They're not gonna be here this weekend, so they don't work on the weekend, so it's gonna be during the weekday next week.
All right, so basically like $6,000, well, $600.
Through a bonding company, 15%, so more like 700. All right, we gotta move on. Mr. Harvey? Mr. Harvey, you've been charged with aggravated battery. Your bond is $25,000. As a condition of your bond, you can't have any contact with Plea. You cannot return to 7381 Chad Circle, Jonesboro, Georgia, 30236. Once and if you're released from custody, you can go with a sheriff's officer to retrieve any undisputed personal property within 10 days from your release from custody. Do you understand the conditions of your bond?
Yes, ma'am. Could you repeat the amount again, please?
$25,000. Your preliminary hearing date is on November the 30th, and based on your application, I've appointed an attorney to represent you. Do you have any questions? All right, thank you.
Mr. Hanson, go ahead and step up, sir.
Mr. Hanson, you've been charged with criminal trespass. That bond is $5,000. Loitering or prowling is $1,000. As a condition of your bond, you cannot go back to BCS Recycling at 107 900 Forest Parkway. Do you understand the condition of your bond?
I do, ma'am.
Your preliminary hearing date is on November the 29th. Based on your application, I've appointed you an attorney. Do you have any questions?
No, ma'am.
All right, thank you.
Thank you, ma'am.
So that way she can see you. She saw you. Go ahead.
Are you Mr. Humphrey?
Yes, ma'am.
All right, Mr. Humphrey, you've been charged with possession of marijuana less than 1 ounce. That bond is $1,500. Tenant window violation is $500. Possession or use of drug-related objects is $500. Your total bond is $2,500. Your preliminary hearing date is on November the 29th. And based on your application, I've appointed an attorney to represent you. Do you have any questions?
If I go through the bonding company, how much is $2,500?
It's probably gonna be like around $300.
Okay, that ain't bad. I'll bond out there.
Okay, all right, thank you.
Thank you. Go ahead, this is Mr. Lacaninia.
All right, sir, you've been charged with simple battery. Your bond is $2,000. As a condition of your bond, you can't have any contact with Danielle Bowman. Do you understand that, sir?
Yes, ma'am.
Your preliminary hearing date is on November the 29th. Based on your application, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am, I do not have any money. I'm only on supplemental security account. Your Honor. I can't afford
Okay,
to
just
tell-
let your attorney know that, and they'll meet with the solicitor's office to see if they can do something about your bond. But for purposes of today, that's how much it's gonna be, okay?
Sir, Your Honor, thank you.
All right, you're welcome. Take care.
Okay, this is Mr. Owens, Your Honor.
Okay. All right, Mr. Owens, you've been charged with criminal damage in the first degree. That bond is $5,000. Loitering and prowling is $1,000. As a condition of your bond, you cannot go back to BCS Recycling located at 107-900 Forest Parkway in Forest Park, Georgia. Do you understand the conditions of your bond? Your preliminary hearing date is on November the 29th, and I've appointed an attorney to represent you. Do you have any questions?
That felony?
I'm sorry, what'd you say?
Felony? Is that a felony?
No, no, they charge you with the misdemeanors. They didn't charge you with felonies. All right, thank you, Mr. Owens.
Thank you.
Go ahead and step up, sir. State your name for the judge. Reynolds, go ahead and state your name, sir.
All right, Mr. Reynolds. Mr. Reynolds, you've been charged with criminal trespass. Your bond is $2,000. As a condition of your bond, you can't have any contact with Trayvon Craddock. Do you understand that, sir?
Yeah, but I live there. I pay rent there.
Yeah. So you can't have any contact with Mr. Craddock as a condition of your bond. Your preliminary hearing date is on November the 29th. Based on your application, I'm assuming you're gonna hire your own attorney or represent yourself since you refused to complete it. Do you have any questions, sir?
So how do I get my bond? I don't understand. I live on that property. This is my house. He don't live there. He's a roommate. Mr. Milton.
Okay, Mr. Reynolds, everything you might be saying might be true. And as you see here, there is nobody here to verify or confirm what you are saying. There's no police officers, there's no prosecutors, there's no lawyers. So everything you're saying could be true. I don't know that. I have to keep the peace in the community. So as of right now, you can't have any contact with Trayvon Craddock. If you have contact with him, you will be charged with aggravated stalking until this bond is modified.
Clothes in that apartment.
You said what?
My clothes and things are in that apartment.
You can
That's
go,
where I live.
okay, so sir, Mr. Reynolds, if you would actually let me complete my sentences, then you would know you can go with the sheriff's office within 10 days from your release from custody to get your personal property that's undisputed, sir. But you won't let me talk, so we can't get to that. Thank you, Mr. Reynolds. Have a nice day.
Robinson, this is
All right,
Robinson, Your
Mr.
Honor.
Robinson, you've been charged with disorderly conduct. Your bond is $1,500. Obstructing a law enforcement officer is $3,000. Your preliminary hearing date is on November the 29th. Based on your application, I've appointed an attorney to represent you, sir. Do you have any questions?
No, I don't have a question. I have a statement. Okay, basically, not about the case. My daughter is like 23 years old and my wife, well, you know, my backbone or whatever, who, you know, pretty much take care of everything for me. You know, past a couple years ago, because of this COVID situation, I've been locked up in like 13 years. I've been locked up in like 13 years. You know, had a pass before, but, and I usually be a little bit more prepared for this. I was actually at the airport, headed out to go to Vegas for a couple days with a friend of mine. And, you know, I had a little dispute with the officer and he basically just didn't like the things I was saying, tased me and all kind of stuff. I couldn't believe it and then charged me with this. But I really wasn't prepared for this because I've been locked up for so long. So I'm saying that to say that like the money, if it's just like maybe 43,050, about 4,500, I'd probably be looking at about $600 to get out, which is pretty not a problem. However, the fact that, you know, my significant other had passed and my daughter's too young or whatever, my biggest problem is probably going to be finding somebody to sign this for me because I just really wasn't prepared for this. It's been so long. I've been locked up since like maybe 2009, 2010. Normally, back when I was younger, I would get more prepared because I used to get in trouble. But ever since I've been all the way 100% legit and I don't get in trouble no more, I kind of forgot how all this stuff go now. And I'm 48 years old. I have a job that I do, you know what I'm saying? I got somebody to take care of. I'm not out in the streets anymore, you know what I'm saying? And, you know, 17, 18, 19 days in jail with just everything that I corrected, that I lost during this pandemic will just be destroyed again if I'm here for that long. The fact that I have went so long without being in any trouble and this is a misdemeanor, and I do have credentials to show that I'm handling business these days or whatever, and I don't have my wife or anything anymore who can bond me out. Is there any kind of way I can get some kind of pretrial release or some kind of help to get back on the streets so I can go to this court date? I lost everything during the pandemic, like everything, and I didn't get no assistance. But I'm just not bouncing. I'm just not bouncing back. I'm just not getting me a place. I just bounced back.
Okay, Mr. Robinson, I've heard your request for a bond reduction. At this time, it'll be denied. That doesn't mean that it won't be reduced later. I'm not doing a signature bond or a pretrial release bond. So you're gonna have to make this bond, or your lawyer that I've appointed to represent you will have to see if they can get the state to agree to some sort of resolution to get you out as quickly as possible. They have to come visit you within the first 3 days. They don't work on the weekends. So somebody will be there at the beginning of this week coming up to get you squared away to help get this resolved so you don't lose everything.
Okay, so that November 29th, that's not my date?
That'll be your date if you're still in custody, if you don't make the bond.
But the resolve quick as possible thing, what did you mean by that?
No, so your attorney will come and meet with you and they'll meet with the solicitor's office to figure out a resolution based on all the things that you just told me. But for purposes of today, like I told everybody else before you, there is literally nobody here to confirm or verify what you're saying. And it could all be true. But because of that, I can't just go off of what you're saying today.
Oh, you don't have my record in your face?
No. I see your record. That don't have any, does your record confirm your wife? Does it confirm your daughter's story? None of that. It just tells me your past.
No, I just thought that maybe the fact that it's been that long since I've been in trouble that you would consider that, but it's all good. I know where I'm at.
All right,
Thanks
take care, Mr. Robinson. Mr. Scott? All right, Mr. Scott, you've been charged with improper lane change. That bond is $500. Violation of the seatbelt law is $500. You have 3 counts of child restraint violation is $500 each count. Possession of marijuana is $1,500. So your total bond is $4,000. Your preliminary hearing date, if you don't make bond, will be on November the 29th. And based on your application, I've appointed an attorney to represent you. Do you have any questions, sir?
Can I get my bond reduced or no?
Yeah, it's actually as low as it could be. It's $500 on all those counts. And the marijuana is the standard bond. So for purposes of today, it's as low as it's gonna get.
Okay, thank you, man.
All right, you're welcome.
Your Honor, this is Mr. Smith. He refused attorney because his bond has already been paid.
Oh, okay. All right, well, if your bond has already been paid, you'll be bonded out at some time. All right, thank you.
Go ahead, Mr. Turner, come on. Gentlemen, this is Mr. Turner. Go ahead, step up, sir. What's your name, sir? Vickers?
All right, Mr. Turner, you've been charged with criminal trespass. That bond is 5,000. Loitering or prowling is 1,000. As a condition of your bond, you cannot go back to the BCS recycling located at 107 900 Forest Parkway in Forest Park, Georgia. Do you understand the conditions of your bond?
Yes, ma'am.
Your preliminary hearing date is on November the 29th, and based on your application, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
Now this is Mr. Vickers, Justin Vickers.
All right. Mr. Vickers, you've been charged with possession of marijuana less than 1 ounce. That bond is $1,500. Violation of Georgia Controlled Substance Act. That bond is 3,000. You have violation of Georgia Controlled Substance Act with the intent to distribute. That bond is 5,000. Possession of a firearm during the commission of a felony is 3,000. So your total bond is $12,500. Your preliminary hearing date is on November the 30th. And based on your application, I have appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
Hey, Your Honor, this is the last mail here, Simon, the last mail.
All right, let's see. Mr. Simon, you've been charged with being a fugitive from justice. And all the rights that I've advised that everyone else also apply to you in your case. And what we're about to have here is what we refer to as an extradition hearing, because you have a fugitive warrant that's been issued for you. You don't have any charges pending here in Clayton County. You have been brought to court today because you have an active warrant number 192302345, issued by the state of Massachusetts, Springfield Police Department from October the 15th, 2019. So based on that reason, you've been charged with being a fugitive from justice. Basically, you can't contest your innocence or your guilt here in the state of Georgia. You can waive your extradition and you can voluntarily return back to the state of Massachusetts, or you can contest your extradition, in which the governor will have to prepare a warrant and a seal. You could be detained here for an additional 90 days if you decide to contest it. What you can do is if you want to contest it, you can file a writ of habeas corpus, in which you can contest whether the extradition documents are in order on the face of them, whether you're actually charged with a crime in the state of Massachusetts that exists, whether you are in fact the person named in the request for the extradition, and whether in fact you are a fugitive from justice. So do you want to waive your extradition or would you like to contest it, sir?
I would like to go back.
Okay, so they have the forms there. For legal reasons, you have to sign all 7 of them. And once you sign them, they'll forward them over there so they can begin the process to come and pick you up. Do you have any questions?
So how long will that process take?
I can't give you the exact time, but I know once you waive it, that speeds it up tremendously.
Well, how long to do that? Because I got
Okay, all right, so just sign those forms and they'll get those transferred back to Massachusetts so they can start the process.
Okay, thank you very much.
All right, you're welcome. All right, so we just have Lopez.
Yeah, just Lopez, did we get an interpreter for her?
No, they don't
She
work
was-
on the weekends. I have to call the language line. So I'm gonna put this on mute while I get an interpreter on the phone, and then I'm gonna come back.
Yes, ma'am. Yes,
All
ma'am.
right, thank you.
Welcome.